Kindly rise. Please take your seats. A very good morning, ladies and gentlemen. I am Yogita Man, Inspector and Compare for today's program. It is indeed a matter of great honor and privilege for me to extend a warm and heartfelt welcome to our chief guest, Honorable President GSTAT, Justice Dr. Sanjay Kumar Mishra, Honorable Members GSTAT, Principal Chief Commissioner CGST and Central Excise Delhi Zone, senior officers, distinguished guests, and all the participants who have gathered here for this prestigious workshop being organized by CGST and Central Excise Delhi Zone in collaboration with GST Appellate Tribunal, Principal Bench, and GSTAT Delhi Bench. May I request everyone to welcome our esteemed dignitaries with a warm round of applause. We are deeply honored to have such an august gathering of distinguished personalities whose vast experience, wisdom, and contributions continue to strengthen the GST appellate framework and enrich the tax administration system of our country. This workshop has been thoughtfully designed to serve as a platform for meaningful deliberations and constructive exchange of ideas on various aspects of GST appellate framework. This session will focus on recent legal developments, various technical, legal, and procedural issues being faced by the field officers in filing, monitoring, and processing of online appeal applications on the GSTAT portal. I would now request our chief guest, President GSTAT, Dr. Sanjay Kumar Mishra, to kindly take seat on the dais. Dr. Mishra is a distinguished Indian judge who had served as the Chief Justice of Jharkhand High Court. I request our guest of honor, Justice Mayank Kumar Jain, to be seated on the dais. Justice Mayank Kumar is a judicial member of GSTAT, Principal Bench in New Delhi. Prior to this role, he was a distinguished judge of the Allahabad High Court. Now, I would request our distinguished presenters, Sri Rajiv Kapoor and Sri S.K. Rahman, to take seats on the dais. Sri Rajiv Kapoor is a 1992 IRS batch officer and has been appointed as a technical member center in the GSTAT. Sri S.K. Rahman is also an IRS batch 1992 batch officer and has been appointed as a technical member center of GSTAT as well. Now I request Principal Chief Commissioner, CGST and Central Excise Delhi Zone, Srimati Rimjim Prasad, to kindly take seat on the dais. May I request Principal Chief Commissioner, CGST and Central Excise Delhi Zone, Srimati Rimjim Prasad, to accord a formal welcome to our Honorable Chief Guest, President of GSTAT, Justice Dr. Sanjay Kumar Mishra, by presenting a memento and a sapling as a mark of our profound respect and gratitude. May I now invite the Principal Commissioner, CGST Delhi North Commissionerate, Shri Shailesh Kumar, on the stage to extend a warm welcome to Honorable Member GSTAT, Justice Shri Mayank Kumar Jain, by presenting him with a sapling. I would now request Commissioner, CGST Delhi South Commissionerate, Shri Dinesh Kumar, to come on the stage and welcome Honorable Member GSTAT, Shri Rajiv Kapoor, to the workshop by presenting a sapling. May I now invite CGST Delhi East Commissionerate Commissioner Srimati Sangeeta Karmakar to come forward and welcome Honorable Member GSTAT Shri S.K. Rahman to the workshop by presenting a sapling. I now request Commissioner, CGST Delhi West Commissionerate, Shri Dipin Singla, to come on the stage and present a sapling to Principal Chief Commissioner, CGST and Central Excise Delhi Zone, Srimati Rimjim Prasad, as a token of respect and gratitude. As we are about to start, everyone is requested to keep their mobile phones on airplane or silent mode. अब जब हम इस कार्यशाला की औपचारिक कार्यवाही का शुभारंभ करने जा रहे हैं, तो मैं आदरणीय गणमाननीय अतिथियों से यह अनुरोध करती हूँ कि वे दीप प्रज्वलन समारोह में सहभागिता कर इस कार्यक्रम का शुभारंभ करें.
श्वेतपद्मासना या ब्रह्माच्युतशङ्करप्रभृतिभिः देवैः सदा वन्दिता सा मां पातु सरस्वती भगवती निःशेषजाड्यापहा शुक्लां ब्रह्मविचारसारपरमा आद्यां जगद्व्यापिनीम् वीणापुस्तकधारिणीम् अभयदा जाड्यान्धकारापहा
अब मैं आदरणीय प्रधान मुख्य आयुक्त सीजीएसटी एवं केंद्रीय उत्पाद शुल्क दिल्ली जोन श्रीमती रिमझिम प्रसाद से सादर अनुरोध करती हूं कि वे अपने परिचयात्मक वक्तव्य के साथ इस गरिमामयी सभा को संबोधित करें.
Honorable President GSTAT, Dr. Justice Sanjay Kumar Mishra ji, Honorable members of the GST Appellate Tribunal, Justice Mayank Kumar Jain, Shri Sanjay Kumar Agarwal, Shri Sanjeev Jain, Shri Arun Kumar Singhal, Shri Rajiv Kapoor, and Shri S.K. Rahman, and all my colleagues present here today. I wish you all a very good morning. As a department, we are indeed very honored to have with us today the President of GSTAT and honorable members of the tribunal, both from the principal and the state benches, including from Chennai, who have kindly consented to interact with the departmental officers today. It needs no emphasis that the operationalization of GSTAT marks a significant milestone in the GST dispute resolution framework. The GSTAT will lay down the foundation for the jurisprudence to emerge. With the commencement of appellate proceedings before the tribunal, field formations across the country have also entered a new phase of tax administration. This requires not only legal preparedness, but also procedural and technological readiness so that we can support the tribunal in its functioning. As many of us have experienced, the transition has brought with it certain practical challenges relating to filing of appeals, etc. While these challenges are natural in the initial phases of any new institutional framework, it requires collective addressing and timely resolution. This workshop, as I understand, has been conceived as an interactive platform. The distinguished panel present here today will explain to us the procedural and operational aspects of GSTAT. At the same time, the panel will share with us their views and expectations they have from us. The officers can also explain the issues encountered in the field, exchange their experiences, and seek guidance directly from the Honorable President and members of the tribunal. The objective is not merely to identify the problems, but to arrive at practical, workable solutions that can facilitate a smooth and efficient appellate process. Sir, today we have officers from 3 GST zones present here: Delhi, Meerut, and Panchkula. The CCs from these zones, I think from Meerut and of course Delhi, I am here. And we have chief commissioners from customs present here also today. I'm particularly pleased to see the enthusiastic participation of various commissionerates and zones. Your presence reflects our shared commitment to strengthening the GST appellate mechanism and ensuring that departmental representation before the tribunal is effective, professional, and legally sound. Sir, we eagerly look forward to hearing from you and to seek guidance from you. I'm confident that today's deliberations will provide valuable insights and contribute significantly to improving our understanding of the procedural and operational aspects of GSTAT functioning. I assure you that as officers of CGST zones, we are fully committed to be a part of the smooth appellate process. I request each one of the officers present here to make the best of the opportunity of participating in the workshop and in making it a success by not only carefully listening and imbibing to all that is said, but also having meaningful discussions thereafter. Thank you.
महोदया, आपके प्रेरणादायी एवं ज्ञानवर्धक विचारों के लिए हार्दिक धन्यवाद. Ladies and gentlemen, as you all know, that the strength of any appellate institution lies in its judicial vision and its legal foundations. May I now invite Honorable Justice Mayank Kumar Jain, Judicial Member, Principal Bench GSTAT, deliver his special address to this gathering.
Good evening, everyone. My Lord Honorable Justice Sanjay Kumar Mishra, the Honorable President GSTAT, Technical Member Shri Rajiv Kapoor ji, Shri S.K. Rahman ji, Madam Rimjim Prasad ji, Principal Chief Commissioner CGST Delhi, other Chief Commissioners of the South Zone and North Zone present here, Shri Arun Kumar Singhal and Shri Vivek Jain Sahab, the technical and judicial member from the Delhi bench, Vivek Chandel, Vivek Tuliji, all the officers and the organizers of this seminar. शुरू में जब कार्यक्रम प्रारंभ हुआ तो मुझे लगा कि आमंत्रण पत्र तो शुद्ध हिंदी में था और कार्यक्रम इंग्लिश में चल रहा है, तो मैं तो हिंदी में तैयार करके लाया था। तो थैंक यू। आज इस कार्यशाला में आप सब लोगों ने मुझे आमंत्रित किया है और मुझे आपको संबोधित करने का अवसर दिया है। मैं इसके लिए आपका बहुत बहुत हार्दिक आभार व्यक्त करता हूँ। भारतीय संस्कृति की एक अत्यंत महत्वपूर्ण सिद्धांत है, धर्मो रक्षति रक्षित है, अर्थात जो धर्म और न्याय की रक्षा करता है, धर्म और न्याय उसकी रक्षा करता है। न्याय व्यवस्था का मूल उद्देश्य भी यही है कि प्रत्येक व्यक्ति को निष्पक्ष, पारदर्शी एवं समयबद्ध न्याय प्राप्त हो। जब करदाता विभाग और अन्य हितधारक सत्य और पूर्ण तथ्यों के साथ न्यायिक संस्थाओं के समक्ष आते हैं, तब न्याय व्यवस्था में उनका विश्वास और अधिक सुदृढ़ होता है। जैसा कि आपको भी तिथि है कि गत वर्ष 25 सितंबर 2025 को जीएसटीएटी पोर्टल का शुभारंभ और लोकार्पण माननीय वित्त मंत्री भारत सरकार श्रीमती निर्मला सीतारमन जी द्वारा किया गया था। यह केवल एक पोर्टल का उद्घाटन नहीं था, बल्कि भारत की कर न्याय प्रणाली को डिजिटल, पारदर्शी और अधिक सुलभ बनाने की दिशा में एक ऐतिहासिक कदम था। मुझे यह बताते हुए भी हर्ष हो रहा है कि गत सप्ताह आयोजित एक कार्यक्रम में हमारे माननीय अध्यक्ष महोदय द्वारा अपने करकमलों से जीएसटीएटी की आधिकारिक वेबसाइट का भी लोकार्पण और शुभारंभ किया गया। यह केवल एक किया गया। जीएसटीएटी आज देश की पूर्णतः प्रथम डिजिटल अपीलीय संस्था के रूप में विकसित हो रहा है। पेपरलेस फाइंडिंग, हाइब्रिड सुनवाई, ऑनलाइन केस मैनेजमेंट सिस्टम एवं आधुनिक तकनीकी संरचना से न्यायिक प्रक्रिया को नई गति, नई दिशा और नई पहचान प्रदान की गई है। आज की इस कार्यशाला का उद्देश्य जीएसटीएटी पोर्टल पर राजस्व अधिकारीगण द्वारा ई अपील दाखिल करने की प्रक्रिया के प्रति आपको जागरूक, संवेदनशील और प्रशिक्षित करना है। मुझे इस अवसर पर हिंदी के प्रख्यात कवि श्री सोहनलाल द्विवेदी जी की कुछ पंक्तियां याद आ रही हैं, जो मैं आपसे शेयर करना चाहूँगा। लहरों से डरकर नौका पार नहीं होती, लहरों से डरकर नौका पार नहीं होती, कोशिश करने वालों की हार नहीं होती। मन का विश्वास रगों में साहस भरता है, आखिर में मेहनत बेकार नहीं होती। कुछ किए बिना ही जय जयकार नहीं होती, कुछ किए बिना ही जय जयकार नहीं होती, कोशिश करने वालों की हार नहीं होती। मुझे विश्वास है कि ये पंक्तियाँ जीएसटी पोर्टल की इस नई डिजिटल यात्रा पर पूर्णतः लागू होती हैं। प्रारंभ में प्रत्येक नई व्यवस्था चुनौतियाँ प्रस्तुत करती हैं, किंतु निरंतर प्रयास, अभ्यास और विश्वास से सफलता निश्चित रूप से प्राप्त होती है। जीएसटीएटी पोर्टल एक पूर्णतः पेपरलेस और अनूठा तंत्र है, जो उपयोग में सरल और पर्यावरण उत्तरदायित्व दोनों को बढ़ावा देता है। यह केवल तकनीकी प्रक्रिया नहीं है, बल्कि महत्वपूर्ण कानूनी एवं वित्तीय अधिकार जुड़े हुए हैं। पोर्टल की कार्यप्रणाली, दस्तावेज अपलोड करने की प्रक्रिया, ई फाइलिंग की तकनीकी आवश्यकताओं एवं अन्य प्रक्रियात्मक पहलुओं की जानकारी होना अत्यंत आवश्यक है। इसी उद्देश्य से इस कार्यशाला का आयोजन किया गया है। मैं सभी अधिकारीगण जो APL 07 के माध्यम से अपील दाखिल करेंगे, उनसे इस अवसर पर अनुरोध करना चाहूँगा कि पहले वो जीएसटीएटी पोर्टल के बारे में पर्याप्त और पूर्ण जानकारी प्राप्त कर लें। अच्छी इंटरनेट कंसिस्टेंट सुविधा अपने साथ रखें। सभी दस्तावेज PDF रूप में तैयार रखें। पोर्टल के दिशा निर्देशों का पूर्ण रूप से पालन करें। अपील में तथ्य, कानून और दस्तावेजों को स्पष्ट एवं सुनियोजित रूप से प्रस्तुत करें। CGST एक्ट 2017 की धारा 109 के अंतर्गत GSTAT के स्थापना का प्रावधान किया गया। आज की तिथि में प्रिंसिपल बेंच नई दिल्ली में कार्यरत है। उसके अतिरिक्त 45 बेंचेस अक्रॉस द कंट्री कार्यशील हैं, जिसमें 51 न्यायिक जुडिशल मेंबर्स हमारे अध्यक्ष महोदय को मिलाकर कार्यरत हैं तथा 45 तकनीकी मेंबर्स कार्यरत हैं। GSTAT एक फाइनल फैक्ट फाइंडिंग अथॉरिटी भी है। दैनिक रूप से हमारे कार्य में आने वाले बहुत से ऐसे तथ्य हैं, जैसे फर्जी इनवॉइसिंग, कर चोरी, क्लैंडस्टाइन ट्रांजैक्शन, जटिल जांच, आधारित मामलों में जीएसटीटी की भूमिका और अधिक महत्वपूर्ण हो जाती है। ऐसे मामलों में गवाहों के बयान, जिरह, शपथ पत्र, डॉक्यूमेंट्री एविडेंस, इलेक्ट्रॉनिक रिकॉर्ड का मूल्यांकन करके ही निर्णय निर्धारित करना होता है। हाल ही में माननीय अध्यक्ष महोदय द्वारा 14 मई 2026 को एक महत्वपूर्ण आदेश पारित किया है, जिसमें उन्होंने संपूर्ण जितनी भी बेंचेस अक्रॉस द कंट्री स्टैब्लिश्ड हैं, उन सब में डिवीजन बेंचेस को कॉन्स्टिट्यूट किया है। सभी अपीलें जो दायर होंगी वो पहले डिवीजन बेंच के सामने आएंगी और वो ये परीक्षित करेंगे कि किन अपीलों में क्वेश्चन ऑफ लॉ यानी विधि का तथ्य प्रश्न निहित नहीं है। ऐसे मामले मूल्यांकन के अनुसार सिंगल बेंच को ट्रांसफर को भेजे जाएंगे सुनवाई के लिए, और जिनमें क्वेश्चन ऑफ लॉ इन्वॉल्व है वो मामले डिवीजन बेंच सुनेगी। जीएसटीएटी में हाइब्रिड, वर्चुअल और फिजिकल तीनों प्रकार से सुनवाई किए जाने की सुविधा उपलब्ध है। दूर दराज में रहने वाले करदाता या जो भी हमारे अधिवक्ता हैं या चार्ट अकाउंटेंट हैं, उनको हर बार सुनवाई के लिए संबंधित बेंच में आने की जरूरत नहीं है, वो अपने स्थान से ही अपना पक्ष रख सकते हैं। इस्टेब्लिशमेंट को क्रिएशन करना एक साल का काम नहीं है, बल्कि एक पूरे पीढ़ी और इरा का काम है। आज हमारा ट्रिब्यूनल एक ऐसे पौधे के समान है जिसे संवैधानिक व्यवस्था की भूमि में सावधानी पूर्वक लगाया गया है और सींचा जा रहा है। टैक्स पेयर्स, प्रोफेशनल्स, डिपार्टमेंट ऑफिसर्स तथा जुडिशियल मेंबर तथा जीएसटीटी के मेंबर्स के सामूहिक प्रयास से यह पौधा आने वाले वर्षों में न्याय के एक विशाल वृक्ष के रूप में विकसित होगा, ये मुझे विश्वास है। यह वृक्ष पीड़ित करदाता को छाया देगा, ईमानदार करदाता को आश्रय देगा, राजस्व विभाग को मार्गदर्शन देगा। इसकी जड़ें प्राकृतिक न्याय के सिद्धांत पर आधारित होंगी। इसकी शाखाएं निष्पक्षता, पारदर्शिता और उत्तरदायित्व की भावना में विस्तृत होंगी। इसके फल समयबद्ध, कारणयुक्त एवं न्यायपूर्ण आदेशों के रूप में प्राप्त होंगे। मुझे पूर्ण विश्वास है कि यह कार्यशाला अपने उद्देश्य में पूर्ण रूप से सफल होगी, और जो जानकारी आज यहाँ हम आपसे शेयर करेंगे, उद्देश्य रूप से उससे आप लाभान्वित होंगे। धन्यवाद। जय हिंद।
Thank you, sir, for your enlightening guidance and highly informative address. It is now my privilege to call upon the podium Justice Dr. Sanjay Kumar Mishra, President GSTAT, to deliver keynote address and set the tone for the deliberations to follow.
Vande Mataram. Jai Jagannath, good morning. Nice to see the hall full. In fact, officers are waiting outside, I believe, because of constraint of space. My dear brother, Honorable Justice M.K. Jain, Member Judicial Principal Bench GSTAT, Honorable Srimati Rimjim Prasad, the Principal Chief Commissioner, CGST Delhi, brothers Rajiv Kapoor and Sheikh Kadir Rahman, members technical from Delhi and Chennai, other dignitaries of the dais. I am sorry, I do not know the names of all the dignitaries, so you must excuse me for not being able to specifically mention your names. Dear delegates, ladies and gentlemen, in the outset, I'd like to thank Madam Rimzim. In fact, few days back, almost 14, 15 days back, she came to give me a courtesy call. And as we are discussing various things relating to GST, it came to light, actually I told her, that I understand a taxpayer's advocate or tax professional making a mistake in choosing a particular bench to be approached for filing an appeal under Section 112 of the Central Goods and Services Taxes Act. But how to overcome, how to accept the revenue filing a wrong appeal, an appeal in a wrong forum. For example, I told her that about 90% of cases which have been filed before the GSTAT principal bench are in fact cases or second appeal sort of section 112 are to be filed before the state benches. In fact, in one case, the commissioner has mandated in the review order that the case should be filed on a particular state bench, but still it was filed in the principal bench. Now, this may not seem a big thing for you, but as we are also very low in staff, and the staff that are deputed to the GSTAT, like us, like everybody in the GSTAT, is a new concept for us. Not only the legal side, but also the court craft. Now, somebody is posted as a court officer. He was in fact working as a inspector of the CGST or the Central Excise or Custom, and then promoted to the superintendent level, and he's asked to go and take of court matters. So a large number of cases has to be transferred from the principal bench to the respective state benches. Of course, we have taken care. I thank Mr. Tuli and Mr. Chandel for that they made it possible to have a seamless transfer of the case from the principal bench to the state benches. Otherwise, what would have been happened? It would have been really difficult for the appellant who has filed the case. Now, this discussion with Madam, she came out with the idea that let us have a workshop, hand-holding workshop for our officers. And on the next day, it was a coincidence that the governing council meeting, governing committee meeting, governance committee meeting for the GSTAT was scheduled, and the CEO of the GSTN, Mr. Sinha, was present, Manish Sinha, the senior IRS officer. And in course of discussion, we also came to the conclusion that this outreach should not only be confined to the revenue officer, but also to the other taxpayers, other tax professionals, advocates, or chartered accountants. And from that day onward, within 9 days, we made a attempt. And the last Monday, for the first time, we had a all India hybrid workshop for all stakeholders. And it was a huge success. And thereafter, each and every bench at the local level are holding hand-holding sessions with the tax professionals as well as the revenue officers. And from this, we came to know actually that there is a lot of misgivings regarding the process of filing and the use of portal. But actually, it is misplaced. These misgivings are misplaced. If you understand the portal, I say that the portal is not easy in the sense that it is not a portal which you have already worked on, like the ITAT or the CSTAT portal, or even the Supreme Court, the High Court portal. Those portals were already in existence for so many years. But this is a portal which took birth on 24th of September 2025. And there has been a lot of work on it. Already 22,000 cases has been filed seamlessly without use of any paper. So if you master the act, the place where I come from is called Balangir. In my childhood, I was told one interesting saying that jar makod se nachas. I'll just give the literal meaning of that, then I'll say what is the figurative sense of it. Only a Madari can make his monkey dance. Nobody else can. So this saying, though it talks of Madari and monkey, it has nothing to do with monkey or Madari. It is with skill in action or mastery over any particular machinery, you can say, or a AI, anything you can say, which needs, how do you call, practice to get to know how does it work. So I was told that I knew how to light a lantern in our village. But when I tried to light a petromox, I could not. You know what is a petromox is? Many people may not be knowing. It is kerosene based gas light, and it takes very highly qualified skilled hand to light it off, and it gives much more light like a tube light than a lantern. So that is what I say. Why I am saying this thing, because if you understand the portal, if you know the law governing the the filing of second appeal, then there will be no problem. It will be absolutely seamless. Absolutely, it will flow like a river or a stream. Now, I have been given to understand that mainly the delegates are of two levels of officers, like very senior officers, like the commissioners of different zones, or the officers who are in charge of taking a review of a order, whether to file its second appeal or not. And secondly, the officers who actually make the filing on the instructions of the commissioners. Now, especially as far as the officers of the high senior officers or high level officers are concerned, my simple advice is, if you go to the National Judicial Data Grid, you know what National Judicial Data Grid is? Uh, you don't know. This is a data grid, which shows the exact figure of cases pending, judicial cases pending before the different courts of India: District Court, High Court, and Supreme Court. Do you know how many cases are pending before different courts in India? Do you have any idea? As on today morning, it shows something like 4 crore 82 lakhs approximately throughout the country. Out of this 4 crore 82 lakhs, 4 crore 18 lakhs cases are pending before the district courts. Approximately 92,000 pending before the Supreme Court of India. So the rest of are pending before the high courts. Why I am speaking this figure? It doesn't apply to us, because the National Judicial Data Grid does not include the cases pending before the tribunal. There is being an attempt right now. In a near future, we will be seeing that whatever is pending before the tribunals, and next, whatever be pending before the first appellate authority, be it under the Income Tax Act or the Customs Act or the GSTAT, will be reflected in the National Data Grid. What I am saying, that if such a big number of cases are pending, while deciding whether a case you should file an appeal against a order passed under Section 107 of the CGST Act, a very important decision, a very onerous responsibility rests on your shoulder. You should not be just routinely adding to the already existing burden on the judicial system of the country. I know that the CBIC has marked that 20 lakhs rupees should be threshold for filing. Am I correct? 20 lakhs rupees for filing a second appeal before the tribunal. But not in all cases you should insist that all cases which is more than 20 lakhs rupees should be, an appeal should be filed. Now, take into consideration whether there has been a settlement of the legal point elsewhere, given the facts situation, and if it is so, then it is no point in filing another appeal whereby the GST will be burdened. Just it is said that there will be lakhs of cases will be pending before us, and there are only hundreds or so members. The other day, my brother Rahman was telling me that if he takes the existing case that is pending before us, it will take 1 or 2 years to finish it. But we are more eager to see that all the appeals that has been generated in the last 9 years should be filed within 30th of June 2026. Now, if we go to the preachings of Bhagavad Gita, wonderful, uh, what do you call, source of knowledge. Bhagavad Gita, you get everything. Even the duties of a commissioner, senior officer, say level 16, I believe, commissioners level 16 or principal commissioners, they have that the concept of loka sangraha, tax as a loka sangraha. It is not like a extraction of money, rather collection of funds for social welfare. And the ambition that you should fund this the revenue, there should be enough revenue for the state government and the central government to provide for infrastructure, security, education, health, etc. It is not actually collection of money for the sake of collection of money. The senior officers' work is not actually generation of revenue. Rather, it is of governance, ethic, and statecraft. Now, somebody says that, sir, why should I bother? If there is 1 crore rupees case, an order has been passed against the revenue, it's better to file a second appeal so that no vigilance file will be opened against me. In fact, the CBIC has conducted a studies few years back and say that one of the reason that the fear among the revenue officers that a vigilance file will be opened if they do not take a view in favor of the revenue. I don't think it can be true. It is only the human uh, psychology that leads to such a conclusion. So, loka sangraha, governance, ethics, and statecraft, you take a decision carefully and then decide whether a, an appeal should be filed before the GSTAT. In fact, the scriptures, Hindu scriptures, say that this itself a yajna. This very purpose of collection of revenue and spending the revenue for the welfare of the people. The yajna is sacrificed by the taxpayer. He pays a part of his earnings as tax to the state government or the government, and the government fosters by providing things which are necessary for the purpose of leading a life with dignity. So there is this loop of sacrifice and fostering, where the commissioners are the custodian. Inefficiency on their part will break the loop. If they do not do, the loop will not break in. Again, if there is evasion of tax, which is their duty to prevent, the loop will break. So, efficiency and stopping of evasion should both be the the objective of senior officers while deciding appeal should be filed or should not be filed. Coming to the persons or the officers who are going to file the exact appeal by going into the portal and uploading the document, our advice has always been that karmasu kaushalam is always a yoga, skill in action. In understanding how to file a case, the first thing they should know that they should understand what are the facts of the case. and what is the law governing that particular case. Once you master that, go to the portal, acquaint yourself with the portal, learn how the portal works, master the portal. Just like the Madari uses his trick, or the snake charmer uses his trick to make animals dance to their tune. You can make the portal dance to your tune. Am I so boring? People are yearning. Or is it because of the early morning breakfast, heavy breakfast? Uh, Either way. Anyway, I think I'm dragging a bit, so it's time up. I just take 2 minutes and finish it. So for filing APL 07 or second appeal, the officer concerned has to be very sharp, concise, and professional. Now, this another issue, another thought came during this GST 80 outreach, that everybody is the Prime Minister's vision or the government's vision is सबका साथ सबका विकास. हमने एक और जोड़ दिया उसमें, सबका साथ सबका प्रयास and सबका विकास. So this is all I want to share with you. I don't want to make you bore you any further with my dragged, what do you call, not very attractive speech. Just a Jain speech was much better. It was in Hindi and with so much of nectar and क्या कहते हैं उसमें रसीला, with a lot of Hindi कविता. I do believe प्रयास करने वाले को कभी हाथ नहीं होता. तो सबका साथ सबका प्रयास and सबका विकास. I wish all well to the half day colloquia and wish that all of you will participate. It should be a two-way interaction rather than an interaction of making speeches and listening, of course, with a bit of wine. Yan, so thoda sa. Thank you very much. You have a nice day. And I must thank the organizers also. Thank you. Thank you.
Thank you, sir, for gracing this gathering with your valuable words and giving us the mantra Sabka Saath, Sabka Prayas or Sabka Vikas. As we are about to commence the presentation session, I would most respectfully request our esteemed dignitaries to kindly take their seats in the front row of the audience area for the smooth conduct of the presentations. First of all, we would have a presentation session by the Honorable Technical Members GSTAT, Shri Rajiv Kapoor and Shri S.K. Rahman. This will be followed by presentation by Senior Consultant NIC, Shri Vivek Chandel. It is to inform the audience that at the end of the workshop, we will be having a dedicated question and answer session. So any queries that you may have in your mind during the presentations may be reserved for the end. Ladies and gentlemen, we are privileged to have amongst us the honorable technical members of GSTAT who bring with them a wealth of experience and expertise in tax administration, adjudication, and appellate functions. Through their presentations, they will share valuable insights into the functioning of the tribunal, the legal and procedural framework governing GST appeals, and the practical challenges and solutions relating to the filing and processing of appeals through GST portal. With these words, it gives me immense pleasure to invite our honorable technical members GSTAT, Shri Rajiv Kapoor and Shri Sheikh Kader Rahman, on the podium to deliver the presentation and share their valuable insights with us. Sir, over to you.
Thank you very much. Honorable Justice Dr. Sanjay Kumar Mishra, President GST Appellate Tribunal, Justice Mayank Kumar Jain, Member Judicial, Principal Bench, Mrs. Rimjim Prasad, Principal Chief Commissioner CGST Delhi Zone, Shri Rahman, my counterpart in Chennai Bench, Member Technical, Shri Arun Singhal Member Judicial Delhi Bench, Shri Sanjeev Jain, Member Technical Delhi Bench, all the senior officers who are present here from the Delhi, Meerut, and Panchkula zone. First of all, my sincere thanks to Mrs. Rimjim Prasad. In fact, you might be knowing Delhi was the first state bench which became operational. First hearing of the state bench was done by Delhi bench. Of course, the principal bench has done a lot of hearings, but state bench. So while we were working for about 2 months, we were noticing certain things that the notices are not reaching or the officers are not coming for hearings. So after Mrs. Rimjim Prasad joined, I discussed with her that these are the things to be urgently taken care, because in the judicial proceeding it is very difficult, that I keep on giving extensions. So in fact, she was very nice. She immediately reacted. She said, I have spoken to my commissioners, and now the officers will start appearing in the hearings. And we did see a lot of change. We saw officers from virtually all the commissioners started coming. And though, of course, they were new, they didn't know much, at least their presence itself was good enough to ensure that, it is triggered. So then, of course, like Honorable President sir mentioned that we felt a need, they felt the need to have outreach programs. Recently, a national conference was organized on 15th, which was highly successful. And in fact, the video is available on the YouTube. You can see that. This is part of the same program. So on technical part of it, we'll be having presentation. Initially, I'll request Mr. Khader Rahman to handle the legal and the procedural part. Then I will handle the issues which are coming, errors, and kind of things which are coming particularly specific to Delhi bench. I'm sure there must be more or less the issues are common, but particularly Delhi bench, we have noticed in the last about 2 months issues which are coming. How to ensure that the entire hard work done right from the show cause notice to I have been part of the service. Both of us, in fact, have been part of the service. And incidentally, I started my career from Delhi. Two of the division which I handled, MOD 4 and MOD 1, are now commissioners, East and North. So I would like that those errors are taken care, the appeals are filed strongly. So with that, I'll request Mr. Khader Rahman to kindly start.
Thank you, Raju. Good morning. Good morning to all of you. It's a kind of, coming back home to Delhi. I've been here from 2017 to 2024, particularly related to GST. I was in the GST Council Secretariat. I was in the DG GST. I was just trying to see how many of the people have worked with me. Not many. So that means the changes are too many in Delhi. Anyway, the topic that is given to us today is departmental appeals in GST before GSTAT. So what I will do is, there are around 12 sections here. I will cover up to section 7. Section 8 onwards, my colleague Rajiv Kapoor will cover. So in this is the plan of presentation. That is, basically I'll introduce about the problem about GSTAT, the GSTAT structure, what is the legal framework, what are the powers and what is the role of authorized representative, how do we handle a divisional bench and principal bench, how do we understand what is single member bench and division bench, and what are the essentials. To that extent I will cover. Balance of the sections, as I mentioned, Rajiv Kapoor will be covering. The first issue is about the problem and why GSTAT was needed. As all of you are aware, GST has started, I hope I am audible, GST has started in 2017, 1st July. From then onwards, the dispute resolution mechanism should have been established almost for 7.5 years, meaning our Honorable President has joined, that's why I've taken the difference, 7.5 years. There has not been any second stage appeal. First stage appeal was there, commissioner appeals, or additional commissioner or joint commissioner appeal. Second stage appeal was not there. And there was a overload. Many people were going directly on the ordering appeal of the commissioner appeal or first appellate authority directly to the honorable high courts. So honorable high courts have been overloaded because they are going on the writ petition appeal. And for every person, as you know, it's very costly for them to go to high court, and high court, costs all that involved are very high. And various high courts are high courts. So with due respect to them, there could be various interpretation of the same issue, and also the recovery has been a big challenge for the department, because for so many years confirmed demands have been pending for realization. Now after GSTAT has come, what is the change? Basically I wanted to show you prior and post. What is the change is that the change that you have seen after GSTAT 24 September 2025 onwards, at least the portal has been inaugurated. The change is that the speed and finality, everything is online, portal is there. We are the only tribunal in the country who started electronic filing right from the day one. So online filing is there 24/7. Then you have got accessibility for all, whether it's for the state benches, principal benches, stakeholders, departmental officers, and various professionals. Then dramatically, obviously, lower cost. It is available right at yours. Every state is available. Unlike CSTAT, which is available at 8-9 places, we are available at every state. And it is also that the difference between the appeal that you file in High Court and the appellate tribunal is that here facts are also considered. Facts of the case is very, very important to decide a second stage appeal. So facts are also considered, and you have a national jurisprudence, because there is a principal bench, there are state benches, each are connected through the same portal. I hope they will be uniform, or to a large extent a uniform jurisprudence will prevail. The greatest strength of this tribunal is that there is a member technical who comes from IRS or who comes from the state service, and there is a member judicial who is basically, he could be high court judge, he could be any district judge, he could be any of the person with lot of judicial background. So the expertise of judicial principles clubbed with technical knowledge, I believe is going to do it in a very good, much better manner. Coming to the structure and benches, you are aware, but still I want to tell you, as you see all over India, there are around 28 states and 3 union territories with legislature, which are called states. So at all these places, we have the benches. Benches are there at around 45 locations. As you can see, I have put the mark here on the India map. You can see that there are regular benches. Regular benches means regular. One bench means, as per the Act, 4 people, 2 judicial and 2 technical. A division bench here, 1 technical plus judicial, 1 technical plus judicial. Like you can see all over India, there are so many 24 places you are having regular benches. There are around 13 circuit benches where the bench will go, sit at that place, dispose the cases and come back. Then there is a sitting benches. Sitting benches means like for example, Tamil Nadu you take, in our case, there's a Madurai and Coimbatore, 1 bench. There are 4 people, 2 people are sitting at Madurai, 2 people are sitting at Coimbatore. So in Delhi, you don't have that issue. Now, if you come back to Delhi again, I wanted to show it to you that in Delhi, as you can see here, I've shown you here, Delhi bench, basically Delhi, there's a principal bench for all over India, being a capital of the country. Sir. We just started, sir. I'm just showing the introductory slide. Yes, sir. So all over India, I was mentioning to them, saying all over India, around 31 benches are there. 28 plus 3, and we are at 45 locations. At regular benches, 24 benches are there. 8 are the sitting locations and 13 are the circuit benches. Coming to the principal bench, I have shown you to here in this slide. It's available at Jeevan Bharati building. Our Honorable Justice Dr. Sanjay Kumar Mishra Sahab is the president, and there are this operational right from 21st January 2026 onwards. And we have Delhi State Bench. Delhi State benches are there notified. Jurisdiction is the entire UT of Delhi, UT with legislature of the NCT area, where all the districts are located, and appeals are heard to the tribunal against the first appellate authority. It is not direct appeal, it is a second appellate stage. And the portal, both experts are here, I did not say, but in one slide I just wanted to show it to you. The portal that is available to you is that 24/7 e-filing is there. You have integration, there is a GSTAT portal. Backside to that, there is a GST portal, which has been existing from 2017 onwards. Am I correct? In fact, all the officers have been accessing GST portal, right? So the GST portal and GSTAT portal both synchronize each other. There is a integration with that. There is a digital cause list. Unlike CSTAT or any other tribunals, the cause lists are not published just offhand. So they are published online. You can see, go to the portal and see in the cause list which case is coming when. They are the smart courtrooms. Right from the day one, there is no paper book. Unlike court, unlike other tribunals, you don't have to file paper, nor we have to see paper. Everything is e-filing only, both for the party as well as the department. All the papers we will be seeing is also in the noting we do it also online we do, and the order we give is also online. That's why it's called smart courtrooms, and the orders are also digital, and you have virtual hearings. Virtual hearings is by default it is physical hearing. You can appear. In case you request for having an virtual hearing, you can have. In case you request, some of the people request, then it can have hybrid hearing also. At the bottom, I have given you all the details: e-filing portal, helpline, and the help center that is available. I have given here. Then we have legal framework. Just to you, because all of you are well experienced officer. I know you are all aware of this, but just my duty to tell you, if you are dealing with a tribunal, if you are dealing with tribunal matter, you don't have to work hard. You just have to read few sections of the CGST Act. I mentioned those sections here, section 109 to 121. Basically, in that also I mentioned very clearly saying that Constitution 109, 111 the procedure, 112 how the appeals are given, 113 for the orders. And if you are dealing with, let us say, refund of interest 115, otherwise authorized reference to 116. A few sections only you just have to read once. Similarly, on the rules side, CGST rules, few rules only, that is 110 to 113A. Particularly, I wanted to draw your attention to 110, where you can file appeal, 110A, which talks about single member bench, what does it do? Then 112 talks about additional dividend. Then there is a GSTAT procedure rules. So these procedure rules have been released from April. So these procedure rules you require to read. Probably you would not have read unless otherwise you dealt with a tribunal. Kindly go through the procedure rules, well drafted and easy to understand also. In those procedure rules also, today I will be discussing upon few rules, let's say rule 29, 31 and 45, 102. And there are forms. One has to be very clear about the form. Like you are having GSTR 3B form, GSTR 1 form. Then the forms that you will be dealing with is APL 07 if it is a departmental appeal. Party appeal they will file under APL 05, online to be filed. In case as a respondent you want to file a cross objection, then you have to go to APL 06. Then you have, whenever you file APL 07, you get an acclamant. It's called APL 02. APL 02 is part A is provisional, part B is final. Then you have, when the tribunal gives an order, it gives out a summary of the demand. Like you give APL 04, same manner APL 04A given. Now, among the forms that are available, apart from those forms which are published in CGST rules, GSTAT procedure rules also given few forms. One of them, two forms are, I think, are relevant to us. That is form 1, that you do it for interculatory application. That's for miscellaneous application when you have filed. And other form is for the whenever your authorized representative appears before the thing. And there is also a commissioner who can use revision. Like in our central election service, we used to have review of the order. Then in GST, we have revision powers also. So revision form is also available, RVN 01. So these are the few forms. Then comes to the circulars. You don't have to search anywhere. I have clubbed everything out here. Few notifications of the CBSE, few circulars, especially some circulars I have quoted here, which are talking about common adjudicating authority, common appellate authority, monetary limits for departmental appeal, and there is a DOR, Department of Revenue circular, benches being notified, state bench territories being mentioned, then principal bench matters, what are the matter principal bench deals, and the office order that has given by our Honorable President on 14th May. So these are the very important ones that you should remember. Only this would be good enough. This presentation will be circulated to you so that you can use that. Now, how important is that? When I want to say about powers of CGST, it's not that we want to say something. What we want to say is how important is, it's not just a second rung in the appellate ladder. It's just that one more tribunal, after this will go to High Court. Please do not understand that. What is the importance of this GST, what I wanted to say. Here, GSTAT, when an appeal is filed, either by the department or by the appellant, what is decided? The appeal either can be confirmed, can be modified, can be rejected, can be remanded back. And you can even say that, if any order is given, that can also be corrected. I can even say that when a person, let's say taxpayer files an appeal, accepting the 10 plus 10, 20%, balance of the demand is automatic stays there. Automatic stays there. So that is also there. Then here, facts are also heard along with the legal matters. When it's a combination of facts and legal matters, and there is a chance here that you can even correct. The rule 101 says there can be rectification. If you want to take some grounds which were not originally mentioned in your appeal memorandum, you can take it under rule 31. In fact, if you want to bring in some evidence which is not taken up in original adjudication or first appellate adjudication also, you can bring it, except in the 4 circumstances that are mentioned in rule 112 of CGST rules, mentioned in rule 45 of GSTAT procedure rules. So these are the various important aspects about the CGST, and you should also remember that it is a civil court. As I have already mentioned it to you, what is the procedure to be done at civil court? Same procedure will be followed at the tribunal. That means you cannot lie, you cannot misrepresent, you cannot file any wrong affidavit. There will be huge implications on that. So one has to be very careful about civil court powers. And additional things I wanted to say is that what are the other powers it has got? It can pass an interim order. Like high courts, it can impose costs also on the appellants. So one has to be very careful on that. It can grant stay, it can even order for refund of the interest, I mean, whatever the pre-deposit that has been done. Suppose you go as a department to appeal to them. First thing it will ask you, saying the first appellate order is in favor of whom? Party. So first thing, have you done your refund of pre-deposit? Because pre-deposit is in 10%, correct or not, sir? You have to first refund the pre-deposit with interest under section 112. Then it will say first appellate authority's order have you implemented? Have you followed? If it says refund, if it says ITC, if it says something, have you done or not? So these kind of questions could be asked. So one has to be very, very careful about certain special powers that this tribunal is having on that. And last one I wanted to mention is about the procedural points. There are a lot of procedural points that will be coming up that I think easily you can understand. Now next I will go to appealable orders, meaning which come, whatever comes about GST matters from first appellate authority you can appeal. But you should also know that following do not come to us. Section 121 clearly says that this is not the jurisdiction of that. That is, as a commissioner, if you transfer a case from one person to other person, or somebody seizes, you seize a document, somebody rushes to first appellate authority, by any chance if he hears, then rush to GSTAT. No, we don't have jurisdiction, nor we are going to hearing of. Then sanctioning of your prosecution, that's none of our business to get into it. And also to say that suppose you give an order under section 80, payment in installments, confirmed demand. Suppose he is aggrieved of that, he cannot come to us. I will add, these are mentioned in the section. In fact, I have added two more also, saying that you do provisional attachment of bank account, right? Right? Am I correct or not? Commissioner does. That also it does not come to us. I will even see even GST practitioners, in case your conduct is not good, if you cancel it, that also doesn't come to us. So you should know what doesn't come to us. And also, you know, saying that if at all department want to file appeal, you have to have minimum 20 lakhs above. Minimum that limit 20 lakhs. 20 lakhs is a cumulative amount. 20 lakhs is the amount that is different. There is a circular that have been given. In that circular, what is should constitute 20 lakhs. That is, if it is a tax plus penalty, you have to take tax. If it is only penalty, then you have to take penalty amount. Like that, they have given the thing. So accordingly, about 20 lakhs only you can come. You know very well, to go to high court, you have to cross 1 crore and 2 crores. But there is an exception. There is a circular here I have quoted here. There is an exception also. You are well aware this exception. We have been doing in central excess service tax also. If this is talking about constitutional validity, there is no limit, doesn't appear. It talks about some ultra virus of a rule, it doesn't appear. It talks about recurring in nature, doesn't this limit doesn't. If it talks about any adverse comments have been given, a specific instruction has been given, that also does not come into this picture. Then coming to the main important aspect is authorized representative. Today, for example, Chennai, we are starting our hearing tomorrow. The first fear that we are having is that, look, we are neutral. For us, whether it is a department or it is a taxpayer, both are equal to us. So taxpayer, to the extent we know, have been conducting mock courts, have been preparing very well. So we are slightly apprehensive or afraid of what is the preparation level of departmental officers with respect to the appeals. First is about authorized representative. Because let me tell you, 25% of the fate of the case depends upon how the authorized representative of the department argues or not argues. I myself have worked as 2 years as Principal Commissioner AR in CSTAT. I myself have argued cases, not just worked. I myself have argued from the day one, the exactly 21st June 2023, till the date I left, I was sitting in the court. That's how I could learn the court craft and all those matters. So I have argued the cases. Many of the people just stand up and say, I reiterate the contents. Believe us, as a judge, we cannot do anything. We have to only listen to you, okay, fine. Nothing else. Even if you know that particular circular, particular section is in favor of you, if authorized representative does not say, no judge will help you to say that, why are you not saying this? So very, very important to first talk about authorized representatives. Like in Chennai zone, they have already allotted to some officers to be authorized representative. We have sent them to nation for training also. They have been given training. So whatever be your preparation level is up to you. What we can only say, saying that what we have been doing outreach program for the trade, now we are doing for the department, equal to us. So who can appear before GSTAT? I have already mentioned, it's mentioned in 116 section. So it could be an advocate, it could be cost accountant, it could be chartered accountant, it could be company secretary, it could be a retired government officer, it could be your own serving officer, You can even ask for authorized person to do. Only thing who cannot appear I have shown here. In case any problem is there with that officer who has already been dismissed, whatever problems are there, that he cannot appear. I also wanted to say special powers that are given to the commissioner under Rule 116, which says that in case you find the very important, please listen. In case you find the authorized representative does not behave properly in the court, and if commissioner feels saying that he has done something wrong with respect to the procedures or the provisions of the act, commissioner can disqualify him to be AR. Commissioner has that power. Rule 116 you can read if you want. Now I just want to come to the core issue. Like Honorable Presidents have also mentioned, many of department when you file directly they went to principal bench. One should understand the difference between principal bench and the state bench. Principal bench is its center. Any orders, please remember this, any orders of principal bench, if you want to appeal, you have to go directly to Supreme Court. If it's a state bench, you will have to come to respect to High Court. Like Chennai bench, we pass order, you have to go to Madras High Court. Whereas here Supreme Court. Now here, as per the section 1095, I mentioned on the top, you can see, is that it mentioned if one of the issues involved, many issues you can file an appeal. If one of the issues, this is applicable for party as well as department. If one of the issues is place of supply, then it will come directly to principal bench. You have to file an appeal to principal bench. Apart from that, there is a provision saying that any other case, any other issue that can be brought by notification to be added to the principal bench. Accordingly, there was a notification that was issued on 17 September 2025. According to that, the following issues are also added. What are they? One is about ISD, Input Service Distributor. Directly you have to go there. OIDR, you have to directly go there. Plus, there is one more also that is added. If an identical question of law issue is pending for more than 2 benches, then with the approval of Honorable President, the case can be transferred to the principal bench. Meaning, if a taxpayer is there, if I am having, just to illustrate to you, if I am having a same PAN number, distinct person, if I am having a Tamil Nadu, Kerala and Karnataka, suppose by any chance same issue is there, I file my appeal in Tamil Nadu, Karnataka and Kerala. Then make an application to Honorable President, Honorable Principal Bench with a request to kindly transfer the cases to them. Then with the approval of the President, it is transferred there at heart. That is very important class, one has to understand there. But there is the question of law. That word kindly remember, I'll come back to that. Then as per the Act, anti-profiting issues are dealt by the principal bench. As per the Act, triple AR orders, like Principal Chief Commissioner and the State Commissioner, you sit and give an appellate order. If there are 2 contradictory orders from one state to other state for the same taxpayer, then they can final appeal to the our principal bench also. And what is state bench then? Can you guess what is state bench? Anything other than this. Obvious answer. Anything other than this. Like you can say about demand, registration, IGST cases also, other than place of supply. It doesn't mean the entire IGST is there. Then what are the things that are mentioned, you can come there. Okay. Now here also I want to make one small issue. If it is Delhi, there is no issue. Because entire Delhi there is a GSTAT. If it is, let us say, Tamil Nadu, there are 2 commissioner, 3-4 commissioner appeals. One commissioner appeal sits in Coimbatore, another commissioner appeal, 2 commissioner appeal sits in Chennai, 1 Chennai 2. So many people have this doubt and many people have been doing some errors saying that it is the location of the taxpayer. Accordingly, I should go to GSTAT, or is it the location of the first appellate authority? The answer is very clear. I have mentioned to you saying that you are not the taxpayer's registration address. You have to go because the section says saying that if you are aggrieved of an order passed by the first appellate authority. So question is, where is he geographically sitting and what is his jurisdiction? You have to see that. If he geographically sitting at, let us say, Coimbatore and jurisdiction comes to Coimbatore, then you have to file an appeal at GSTAT Coimbatore, not GSTAT Chennai. In fact, out of the cases that are filed, sir, around 37 cases we have transferred to Madurai and Coimbatore because they don't belong to Chennai. Just an example I have quoted there. Now, single member and divisional bench. As I mentioned to you, bench as per the Act means 4 people. 1 technical, 1 judicial, 1 technical, 1 judicial. Senior most judicial called Vice President. Now, if we want, each single member can sit and dispose the cases if 2 conditions. What are they? Number 1 is if the amount of dispute involved is less than 50 lakhs and question of law is not involved. Then single member can sit and start disposing the cases. But in case the amount involved is more than 50 lakhs and question of law is also involved, in case question of law is also involved, then it has to be compulsory held by the division. Divisional bench is 1 judicial and 1 technical. Now, I have mentioned that to you, it's very clearly mentioned. Honorable President has given an order. According to that order, that cases, listen to me carefully, cases which are less than 50 lakhs, first comes to the division bench, to judicial and technical seat. Then they decide whether question of law is involved or not. If it's less than 50 lakhs, automatically should go to single bench. Marking is not done by vice president or president as mentioned in the rule. As per the order given by Honorable President 14/5/2026, first it will go to divisional bench. They will sit and see the short point. What is the short point? Amount is less than 50 lakhs, no problem. But whether question of law is involved or not. That is also following principles of natural justice. They will ask appellant counsel, bhai, what do you say? He says question of law involved. Departmental counsel, he says no sir, not involved. Then they also feel say not involved, go to single bench. Suppose one person says no sir, question of law involved, he should go to divisional bench. One person says question of law is not there. Then they hear both the parties pass a simple order saying that question of law involved or not. Accordingly, they mark it to the divisional bench. Divisional bench orders are binding upon single bench. Single bench orders are not binding on divisional bench. Suppose there is a show cause notice. Notice one is tax plus penalty you are demanded. Notice 2 is only penalty. Suppose notice 2 files and directly goes to the single member bench because less than 50 lakhs question of law not involved. That case, suppose he is trying to decide. How can you decide penalty without deciding the tax? Whether the case is there or not, you can't decide, no? Suppose divisional bench takes a decision saying that notice one demand is upheld, then automatically penalty will come. Penalty case cannot be individually decided without even knowing whether there is a case or not. Am I correct or not? All of you agree? Yes or no? Yeah. So that is why I am saying the divisional bench orders, single member bench orders are not binding upon a, vice versa is that. Then coming to the question of law, two places you have heard question of law, where number one is that when single member bench, divisional member bench, when it has to go, acha, here you can make an application. Appellant can ask, I want to go to single bench. It can be decided by the divisional bench, different matter, but there is an option for you to ask. There is also the question comes question of law. Now, what is question of law? Can you answer what is question of law? I feel it's very difficult to answer, sir, with due respect to Honorable President. I can only say what is not question of law. Easy to answer what is not question of law. That is question of fact. What is question of fact? Where the goods are actually moved, services are not rendered or not, invoice is genuine or not, recipient exists or not. These are the facts. I mean, hardcore facts. So facts are involved. Yes, it is a question of facts only. But most of the cases, listen to me, there is a question of law plus question of facts involved. Most of the cases. That is why our Honorable President has given that order in which he said, saying that let the divisional bench decide whether question of law involved or not. If it decides question of law involved, automatically it will go to the divisional bench. So I have mentioned here a few examples of question of law, but this will come through a workshop, through a decision. It has to come through a judicial order. So it says saying that, let us say, interpretation, jurisdiction, procedural things, and whatever the wrong legal principle, classification dispute, all these are generally are question of law involved. Now coming to the another order. This is another order given by our Honorable President on 14th May 2025, in which the cases have been categorized. Because there are so many benches, so many judicial and technical members, the work has to be distributed. So it's called bench formation order. In this bench formation order, three categories have been mentioned. Category 1, which are dealing with classification etc. matter. Category 2, registration, refund, assessment. If you have manual, some of you are having manual, Shaukat? No, I have. If you have manual, kindly see the manual. April 05 or 07, if you see, there is something called category of cases. 38 categories have mentioned. Chandel sahab, aapko to yaad hoga. 38 categories are mentioned. These are those categories. Those categories have been subgrouped into category 1, category 2 is about registration, refund, etc. Category 3 about seizure penalty. So our bench formation, certain categories are allotted to certain. For example, Chennai, category 1 and category 2, I deal with my judicial member. Category 3 is dealt by another member coming from Coimbatore who sits with my judicial member and decides. Like that distribution has been done. Either you can ask for, you can have an opinion which is category, otherwise registry and the bench also will decide which category is that. Now coming to the nodal officer, your main role, the very purpose for which I have, this is my last section that I will be covering, then Rajiv will come. Here, please understand one thing, that when it is a taxpayer, they are able to file. When they are able to file, when they file, appeal number gets generated April 02, automatically those set of documents should come to you. Now the question is, if you start hearing there, department is, no, we have not received. The problem is that the entire setup, how is designed by NIC and GSTAT has to be very clearly understood by you. How is it done? For the entire portal, there is one BO. This is called backend officer. This is an officer, one nodal officer nominated from you. Now this officer is the nodal officer who receives everything. He is the nodal officer. I mentioned it here if you can see. He receives, if a party files an appeal, first it comes to him on his portal. And the GSTAT username password is given. He has to open up the username password. All the appeals filed by the party appeals will come to his dashboard. What does he do? He does by nominating SOs, section officers. He will, like each commissioner, like you are having zonal level 1 BO, you are already nominated. So he will operate as per the convenience of the zonal chief commissioner or the commissioner, one section officer from each commissionerate, division, whichever manner you want. Then he will immediately forward those papers to the concerned person and serial number for AR. Whoever is the nominated AR. There is a set of ARs who have been nominated. Otherwise, CSTAT office, there is a CCR office. Exclusive ARs are there. But here you are nominated or you will be nominating some people to be AR. So AR also copy goes so that he starts preparing on that. Then they will file a reply, then they will argue the cases. If it is other way around, let us say you want to file an appeal. Now, where does the file an appeal? Either you can ask the commissionerate SO officer to directly file an appeal. I don't know how it is designed, state to state it changes. And some states they have said saying that no appeal preparation you do, send it to the nodal officer. Let the nodal officer directly file on the counter. So either way it is possible. Or suppose you file an appeal, departmental appeal. There is a defect raised. The defect first comes to whom? To the nodal officer. The nodal officer will see which section officer is concerned, he will send it to them, then they will rectify the defect, then defect will be cured. I mentioned all those here, nodal officer, I mentioned about sub office, it's called sub office in our GSTAT IT terminology, but you can always call whatever you want. Then it will go to the respective. This kind of coordination is very much necessary, especially notice. The case is coming up 23rd tomorrow, notice goes. The departmental officer, no sir, we have not received notice, we never knew. Arey bhai, it is on the portal, digital cause list is available, notice has been sent to you. We have sent, you will say, no, I have not received. Where does it go? It go to the nodal officer. Nodal officer exclusively should sit and morning to evening, he should keep watching what is coming onto the portal and quickly, like a post office, quickly send. And whatever comes from the offices, he should quickly assimilate and upload it onto the portal. This is a very, very critical role. Unlike in CSTAT, where departmental appeal filed the various commissioners, here is a slightly different system is done. This has been thoughtfully done because they have worked for high courts and all that. Accordingly, they have designed that. I'll request all of you, there are 8 pages that are given by the NIC GSTN. How does the BOS4 system work? I'm not going to bore you with all those things. So kindly read once, then you will understand that. So I'll stop at this level. I'll request my colleague Rajiv Kapoor to take over from part 8 onwards.
Is the mic working? Okay, thank you, Khader. I think Khader has already elaborated a lot on the legal and the procedure part. As I mentioned earlier, our experience, I'll be sharing with you the experience of about more than 2 months in Delhi bench particularly, and issues which were coming, and one Mr. Khader has already mentioned, is that typically we were noticing that party has filed the appeal and notice has gone to the department, but nobody is appearing. So, when the hearing starts, we have to again now decide, and we are not sure whether officer has actually received or not. So, one is, of course, the moment the appeal is registered, it goes through the portal. Second is we started sending through the mail also. We started sending mail to the commissioner as well as to the, in one case, to the principal chief commissioner also, 2-3 cases. And in one case, it so happened that one senior advocate of Delhi High Court, he was appearing. He said, you are sending notices, they are not responding. Then we resorted to section 169, which says that it should be delivered either by the registered post or by the courier. So before I really go ahead, my request to you is, there is a very detailed user guide, FAQs, videos available, made available on the GSTAT portal by NIC. They are very informative. Please spare some time, go through it. It lists the entire process of appeal filing, and that will be very handy. And secondly, another important thing is, there is a, I'll just come that, there is a downloadable e-file is there, which is actually maps your AP05, APL05 or APL07. You can fill that up before you actually start doing it in the portal. So one issue which was, we have been receiving a lot of representation from the tax professional as well as from the department is, in the DGGI cases, where should the appeal be filed? Which bench appeal should be filed? So in this regard, in Delhi particularly, we know that I am taking this particular cases specific to Delhi, but you can apply that to Meerut as well as to the Panchkula zone also. So in Delhi, we have this Principal Chief Commissioner, then Principal Commissioner Delhi North, Delhi East, Delhi South, Delhi West. Principal Commissioner Delhi North and Delhi East, they come under Commissioner Appeal 1 or the Additional Commissioner Appeal 1 Delhi, and South and West comes under Commissioner Appeal 2 or the Additional Commissioner Appeal to Delhi. I hope I am correct here. All appeals under Section 112 of the CGST Act must be filed before the bench having jurisdiction over the territory over which the first appellate authority exercises jurisdiction. This is very important because jurisdiction will really decide where your case will be heard. Like Mr. Rahman was just mentioning that we are seeing a lot of cases which should have been filed in the Delhi bench, but they are filed in the or which said state bench, which have been filed in the principal bench. And similarly, there are many cases who have been filed in the principal bench should actually have been filed in the state bench. So there is unnecessary transfer of cases. Though our Honorable President has been very, very proactive, he has been ensuring that there is a seamless transfer of the cases. But this will unnecessarily, involve hassles, and the issue of jurisdiction will come definitely. So here there are two circulars which I think all of you need to notice. The circular number this 239 by 33 24, which is 4th December, which decided the common adjudicating authority. And similarly, there's an order, circular number 250 by 2025, 24 June, which actually prescribed where will be the first appellate authority for the cases which were adjudicated by the authority which was decided by this circular. So accordingly, if cases are coming from Delhi North or Delhi East, it is the Commissioner Appeal 1. And if it is coming from South and West, it is Commissioner Appeal 2. Like Mr. Mahan mentioned, it is very, very important that where the first appellate authority was. So you have to, accordingly, file your further second stage appeal. I'll not take much of your time. Mr. Rahman has already elaborated a lot on the procedure part. I'll try to stick more to the mundane issues of appeal filing. What are the problems and issues coming? But just quickly going through filing authority, APL 07 is auto-generated. So 1123 says Commissioner may direct any officer to file application on department's behalf. So limitation is 6 months from the date of passing of the order. Please be careful. There is some confusion. A lot of times I heard it is date of communication. 1121 and 112, there is a difference. 1121 says from the date of communication. 1123 says from the date of passing order. So your limitation will start from the date of passing of the order. Please read 1123 very carefully. Monetary limit, of course, it's more than 20 lakhs, except in certain cases which are prescribed in the circular. Stay. Another issue which is recently, Honorable President Sir has set up a committee, to look into the grievances which are coming from the tax professionals. And one of the grievances which has been brought by many people is that despite our giving, there was a circular by the CBIC that if you give a pre-deposit, it is a deemed stay. Actually, it is there in the law itself. But still, officers are enforcing they are attaching the bank accounts. They are enforcing that recovery proceedings. Please be careful. If the pre-deposit has been given, the balance automatically stayed as per the law. Okay. So there are two scenarios. One is you are an appellant. The second scenario is you are respondent. Now this part is also very important. Please understand. Because when you are respondent, there are fixed timelines. The problem I remember when I used to handle my review branch initially as DC, my commissioner used to say, Rajiv, whatever problems have come in this department is handling the review branch. Because the problem in this case is timelines are fixed. Nobody has power to change the timelines prescribed in the statute. There's a big debate going on whether period can be condoned or not condoned. There are many judgments by High Court as well as the Supreme Court. So please be careful about your timelines, okay? So similarly, as a respondent also, you have a lot of responsibilities. Let us say the registry has sent the notice to you. So you have received the notice, your timeline starts now. 30 days, you want to respond? Respond. I will request all of you to please respond. I am seeing in so many cases, rather not even a single case in which from the Delhi response has come, from the commissioner, not even a single case. Whereas on the party side, interestingly, you will not believe, we had a case in Delhi. There was some issue with the portal. Now, when the issue is when does my clock starts, So when the appeal gets registered by the registry, or when you file the appeal in the portal. So when you file in the appeal in the portal was, I think, I don't know whether Vivek it stands corrected or not, but portal sends to the respondent, that appeal has been filed. Now this party, thinking that appeal has been filed and he has 45 days, he filed the counter memorandum of cross objection. No, appeal is still not registered, but he has filed the memorandum of cross objection. Now, see, imagine you are dealing with this kind of, the other side is fully prepared. We have to prepare ourselves. 30 days, 45 days, 30 days you want to respond, 45 days you want to file memorandum of cross objections. That again I will request the jurisdictional commissioners or the ACDCs whosoever are there, please go through it. Don't just wait for the last date. Please go through it as soon as you receive. You want to file response simply, or you want to file, there could be there can be issues in the first appellate authority order which you think got ignored. Because many times I am seeing first appellate authority has completely dropped. And there were some issues when the beautifully, South particularly, I saw very beautifully review orders have been drafted. So they are challenging on many areas, But let us say first appellate authority decided the matter. Now, if you want to file the cross objection, please file within the 45 days after you receive the notice, because it is deemed to be a appeal filed by you, okay, as per the law. And similarly, one case which Principal Chief Commissioner also told me, and a couple of people have told me, we ourselves noticed that in many cases the name of the AC is coming. It's some Pankaj Kumar Mehra versus so and so, or some Mr. Meena versus so and so. There we are working with the NIC. We are trying to ensure that the designation goes and not the name, because officers get transferred. It becomes very difficult to link. Who was the earlier AC and who's the now AC. So that is taken care, because that is part of your process flow. The process flow, when you go and enter the name of appellant, it first asks name, then it asks your address, designation and all. So when actually it is going and preparing the cause list, so it is first giving name, let us say Pankaj Kumar Mehra versus so and so. So similarly, on the other side, if you find that respondent is wrong, you can mention it, that the respondent is wrongly mentioned, because the default rule is, as per the GSTAT procedure rule, jurisdictional commissioner is the respondent, whether SGST or CGST. The law says commissioner is the respondent, not the first. Many cases people are saying first appellate authority versus, or they are saying additional commissioner so and so, or deputy commissioner so and so. No, commissioner jurisdiction is the default respondent. So quickly, timelines, we all know 6 months, which is extendable by 3 months. Now, another very important issue, if you think that you are missing the timeline, please, in your appeal, file the sufficient cause. Give some reason that this was there, AC was on leave, so and so was not there, this happened, that happened. Give sufficient cause, because if you don't give sufficient cause, tribunal cannot give you extension. Don't expect that tribunal, because I have filed this thing within 3 months period, and tribunal on its own will do. No, tribunal will not give till you give the sufficient cause. Please mention in your appeal what is the sufficient cause, why you could not file in time. Okay? Then 3 months is there. 9 months, then there is no further extension to this. So, like just small example I have given, you can start your clock T90, now T60, T30, T20, T10, so that I know my clock. Like typically we used to maintain register earlier days, as ACDC or as joint additional. So that timeline, I had told my staff very clearly, I will not entertain if I, at least as a commissioner, I am not given 10 days. But it invariably used to land on the last date. Sometime even 5:30, I would be clearing the files of the last date of. So please, timelines are very important. We have to ensure this. Then cross objection I have already mentioned are very important. Additional ground, yes, some grounds were not taken at the time of filing appeal. Rule 31 says that you can take those additional ground at the time. Tribunal can allow it, discussion with the tribunal. Then additional evidence, Mr. Rahman has already mentioned, Rule 112 read with Rule 45, so I will not get into this. More or less, interlocutory application, yes. Early, you can file for early hearing. You know, earlier we used to file for high revenue cases. There would be typically direction from the board that these are high revenue cases, please file early hearing. So file early hearing wherever you feel that, the high revenue is at stake or repetitive, or, there is a matter which you think that it will have consequences. So you want it to be decided fast or early. So file the early hearing application. So just a quick elaboration into the fields in the APL 7, GST of the taxpayer. Any question? Sorry. GST of the taxpayer, name and address, order date, all these details are there. So please ensure that they are properly filled. Core orders are very important. Order in original, order in appeal, show cause notice. These are the very essential requirements. Authorization and identity. There should be proper authorization given by the I hereby authorize Shri so and so, assistant or deputy commissioner, Vasant Kund division or so and so division to file the appeal on my behalf. Okay, so authorization should be very well written. Email ID for the service. Details of the AR if appointed. I'm not sure whether Delhi you have appointed the ARs, because see, in CSTAT and all there is slight advantage, I would say, because you already have a very good institutional setup of ARs. Then you have additional commissioner, even chief commissioner AR is there. Whereas GST we have just started. So we are, and the hearing has already started in most of the benches now. So please, we have to ensure that a proper, till the time the DOR or the CBIC takes a decision in finally appointing people, whosoever you are appointing, don't think that any superintendent or inspector or anybody is posted, so let him go, and please ensure that little, I think would say well-informed officers are there and they monitor it. So this is again very crucial. Memo, of course, more or less I have covered. So departmental appeal, there is no pre-deposit, no court fee there. This is one of the major issue as far as the taxpayer are concerned, that 10% of what amount, admitted amount, balance amount, whether first appeal. I have already deposited at the time of investigation. I have already deposited through DRC 03. So a lot of issues are there. Fortunately for the departmental appeal, there is no such issue. So you can go ahead easily. Little practical guidance is there. Once you receive the first authority order, review merits. I will not take much of your time. These are all procedure matter, more or less covered. So this is one area I would like to focus more. What are the common defects in general, and what are the common defects noticed by us in the Delhi bench, particularly, when we were our already, I think, more than 200 cases we have scrutinized. Majority of the cases have been listed also. So, but these are the things which we have noticed while our registry was working, and fortunately in Delhi bench, all the members, many times, because our registry also is new. See, they are, many of them are not actually from the department. They are not very familiar with our GST mechanism. So we are sitting with them, also guiding them wherever the issue comes. So what are the common defects? Please note, this one is appeal is barred by the limitation. Be very careful, file within 6 months. Wrong form is used, APL 05 instead of APL 07. So prayer is not specific, in general, as deemed fit. So that is not the way. You please, like Mr. Rahman was just mentioning, the power of the tribunal. It can modify, it can annul, or it can, set aside the order. So, but please specify what you want. You want the first step authority to be set aside, or you want it to be modified, or you want tribunal to remand it, or what exactly you are asking for. Don't simply say that as deemed fit. So it is. I'm just saying from the practical point of view, it's more better. And closures are missing. They are not properly numbered. In fact, in the initial phase, when we were noticing in most of the cases, I would say 90% cases, that columns in the APL 07 are not filled by the department. They simply say as per annexure, as per brief facts, as per annexure, statement of fact, as per annexure, grounds of appeal, as per annexure. Now that is not the way. The portal is designed in a particular way. It captures, like President Sir was just mentioning, that that is on that basis we decide where the jurisdiction. So many cases wrongly it is picked up. So if I know in brief the statement of fact is their ground, so I'll be able to quickly decide, okay, no, this case doesn't pertain to me, it is a place of supply matter. So, and beside that, it gives a broad summary to the bench. So, and plus I am sure NIC, when it has designed it, it would like to do little data analytics on that also, basically what kind of issues are coming. So those are important area. But I am initially we were raising defect memo. President Sir has, Honorable President Sir has issued a guideline. I must please go through that. It prescribes only 5 or 6 for APL 07. I think Mr. Rahman has mentioned in his this thing. Please go through all the instructions which have been issued by the principal bench. They are very specific to the filing part. So it clearly prescribed that if these things are there, registry will not raise any defect memo. So we are not raising any defect memo as long as you have attached, even if as a PDF or as a one single page. So typically we were seeing is one single page is uploaded, and when the specific columns are there, as per annexure, as per annexure, as per annexure. So nothing is actually there in the form. So it was very difficult for us to, in the initial phase, to whether to allow it or not allow it, take it as a defect or not take it. But now we are not strictly taking it. We are going ahead with the whatever you are, as long as these basic things are available to us. The show cause notice, order in original, order in all these things are there. We are taking it. Okay. So please go through that instruction. So filling in wrong bench, as already mentioned. Achha, then there is no valid authorization by the commissioner. Please, again, I am reiterating, please take valid authorization when you are filing the appeal. Vague grounds of appeal, that's a more, I would say, not a filing issue, more we have to be serious about it while we are giving grounds of appeal. What are the grounds we are appealing? Impugned order not properly identified, no pre-number index of document, no application for early hearing. Any case that if that is needed, you file, otherwise not required. Structure of well-drafted grounds of appeal. So this is just an illustration. I am not saying that you follow please this, but this is a small kind of, you can say, template. What could be there in your, how can you design your this thing. Challenge to the legal proposition, cite the exact section, rule, notification. Please be sure. Don't quote row. I have seen some cases, instead of 74 or 73, 76 is quoted. No, 76 is totally different. 76 is tax collected but not paid. Okay. So please be careful which section you are invoking. Factual errors are there. FA misread, ignored, or misconstrued evidence. So if you are noticing it, please bring it to the notice. Okay. Make it in your appeal. Procedural impropriety. Natural justice was violated. Non-speaking order. Let us say first appellate authority, in the rush of pressure, or the last date was approaching, he has just passed the order without listening to the department. Okay. So, or any, if let us say normally it doesn't happen, my own experience as first appellate authority is very rarely from the department side people come. But still, if you find that he has not applied the principle of natural justice, you mention it. Wrong application of CBI circular. There was a clear CBIC circular was there, or a notification is there, or a board instruction, but he has just ignored it, or not followed it. Valuation classification adopted incorrectly, without prejudice, alternate ground. You can give alternate grounds. You can say that without prejudice to my main ground, these are my alternate grounds. You never know. Your alternate ground can be stronger than the main ground. Each ground should be self-contained, number, site, OIA, para being challenged. Avoid contradictory grounds unless expressly stated as alternatives. Statement of facts, 2000 words, chronological involvement. So common drafting mistake I have mentioned, you many times you just copy the show cause notice. You don't mention what is there in the first appellate authority. Not addressing specifically why FA's reasoning in each paragraph is wrong. Then you mention impure order is illegal without mentioning why it is illegal. If you are saying it is illegal, please mention why it is illegal. Not identifying which specific finding of the FA is being challenged. Mixing multiple distinct issues in a single ground. Not citing the case law, again very important. I was recently, now because time was there, we have been going through all the appeals, also reading on the portal. I noticed when, of course, I might have myself done the same thing, I'm not denying. But when you sit on the other side, you realize, how weakly we defend our cases. Now, let us say first appellate authority has quoted some case laws. Now, you please, when you file now you are coming against the first appellate authority order. So you please say why those case laws are not. If there are other case laws, please mention that. You simply mention 2-3 case laws general and then finish. My job is over. So please, if you want to strengthen the hands of your case, you want to strengthen your case, please do mention that, okay, these are the case laws which are used by first authority, but these are the factual metrics which he has ignored, which was there in my case is totally different. For example, 74, you are saying no suppression was there because audit was done. If audit was done, whether audit para mentioned that issue or not. So like this, there are, you can really, like I have received the goods, I have done the payment. Typically in fake invoices cases. Now you want to puncture that, and he has quoted already 3-4 case laws. Now you please bring your case laws. Yes, though there are case laws on this, but since goods were not received and this was the evidence, even if I would say show cause was weak, but you bring the case laws. You say that this case law is defending my Honorable Supreme Court, Honorable so-and-so High Court has actually upheld it, this issue. Not countering each and every finding. This is again very important. Sir, just 2 minutes. I'll quickly mention. 115, please go through it. Pre-filing, now Delhi State Bench, small data, I would say, APL 07, I think it is increased some 500 something. So it is, please ensure that by 30th, all the prior period cases are filed. Time is running very fast. Please go back to office, try to ensure that all the files. So this I mentioned earlier in this thing. Please go through it. There are user guides and FAQs. There are very nice videos. Please run the videos and see. Like I mentioned, e-filing template, download it. So it will help you in, you can prepare rough, maybe in the next phase, NIC will directly, you can upload from there only. But at the moment, you can download and fill it up. And then, typically I mentioned like Delhi bench, digital signature. Another issue which you are facing is digital signatures are not there. Initially, I was told that some officers don't have digital signature. I hope now everybody has in Delhi. Initially, everybody was telling, sir, I don't have DSC, I don't have DSC. So they were not able to upload digital signatures. Proper filling, please fill all the columns, very important. In the demand order which you fill up details, please fill up all the columns. Mention the disciplinary selection of category, uploading of the review order, correct GST and uploading of documents, bookmarking. So I will not get much. So this is the basic, framework which is used 7 days. Like Mr. Rahman had mentioned, invariably it is directly coming to us. The nodal officer has not been looking into this. So 7 days period, it was landing directly into the bench. Plus, then registry gives you time. Initially, we were very, this thing, no response was coming from the government. Finally, registry had to give a PH rate, and only PH correction started happening. Upload the system generated APL 07. So key takeaways, I think from today's lecture, a lot of issues Mr. Rahman has also mentioned. I would say limitation very, very crucial. Please start your register or whatever mobile reminders on limitation APL 07 jurisdiction, single division bench, documentation and PDF quality, implement FA's order like Mr. mentioned. If he has given already the refund, please give. Don't wait that since appeals filed. So thank you very much. We'll take any question which comes along. Thank you. In the end, we'll take, sir. We'll take question answer.
Thank you. Thank you for your patient hearing.
Thank you, sirs, for that highly informative and insightful presentation. Your lucid explanation of the various aspects of GST has undoubtedly enriched our understanding of the subject. With the GST Appellate Tribunal now operational, it is essential for the officers to have a clear understanding of the procedures and functionalities available on the GSTAT portal. To provide us with a hands-on understanding of the portal and to address the common issues being faced while filing appeal applications, we shall now have a live presentation by Sri Vivek Chandel, Senior Advisor, National Informatics Center. During this session, Sri Chandel will walk us through the various features of the GSTAT portal, highlight the common difficulties encountered by the users while filing process and demonstrate the practical solutions and best practices for resolution of such issues. May I now request Sri Vivek Chandel to kindly come on the stage and take us through the live presentation.
Good afternoon, everyone. Honorable President, respected judicial and technical members, and respected tax officials. So, though we have a really short amount of time, even then, I'll try to explain a bit the flow of the filing on the both side. When a taxpayer files, when you are the respondent, and where a tax official files, when a taxpayer is respondent. So here you can see the tax official login. Just after a tax official logins with this credential, this is the first dashboard page comes up, and in the applicant corner you see the filing, appeal filing, and here is the page where we file the appeal from. All the tabs, order details, basic detail, case detail, appellant, respondent, demand, upload document, checklist, and final preview. Taxpayer filing and tax official filing is almost same, just the payment section is not there. There are two ways to file with ARN CRN or without ARN CRN. Though most of the cases they have offline paper orders, so the ARN does not exist on the system to be fetched directly. So you can use the second option, ARN not available. The only difference is the few fields you need to fill out manually only. In case via the ARN, these fields in the order detail page, these will auto-populate directly fetched from the GST system. But in case of ARN not available, of it's a physical order, you can just fill it here. And all the other details, though the page is long and we have a short in time, so I'm showing you two other things also, the user, nodal user and the BO user. Because nodal user credentials are already being created by the system and being mailed to all the nodals across the system, center and state. And the BO users, they register themselves on the portal. Let me show you how. Going to the register page, the tax official. Here, the select state or center, the jurisdiction, suppose it's Uttar Pradesh. Sub-jurisdiction, you will see all different sub-jurisdictions along with the head office. Maybe some states doesn't have the head office, the center employees, but most of the state has. Then they will select their sub-level, their role, sub-level division, then role. Accordingly, they know their details and they can register over here. The name and email ID will be available, and they will just final submit it, and that BO user will be able to log in on the portal for filing any type of appeals. So let's see another user, which is a nodal user, and what are the activities. Actually, as per the flow in the taxpayer system, when a taxpayer files an appeal, the appeal directly goes to the nodal officer, relative nodal officer, as per the appellate authority being selected during the filing. And that nodal officer assigns that case to a subnodal or sub office, you can say, or the BO directly for the representation of the case. So there are two activities for a nodal when a new case arrived filed by a taxpayer, where the tax officials, yeah, you can say revenue as a respondent. One thing is the verification of the case. There are three things to verify when a new case is filed. One is the jurisdiction, if the jurisdiction is correct or not. Second thing is the pre-deposit. The pre-deposit has been properly submitted or not. And third thing is the details of order appealed against, the impugned order, the appeal 04. So these three things need to be verified by the BO, and this verification will be assigned by the nodal to the BO. And for now, it's for the 7 days, it stays at the BO to verify. If the user doesn't verify, the BO doesn't verify these three steps of verification, because the stay, the main thing, the stay only can be applicable when the pre-deposit is verified. That's we initially envisioned, but for now we are saying the lot of verifications are pending. So we have also assigned this activity to the registrar and the scrutiny members, where they verify the pre-deposit. We have also provided them the proper channel to verify and see the live ledger to verify the pre-deposits, so then stay can be applied appropriately. Second thing is, after the verification, even if the case being verified by the BO or not, after 7 days the case lands to the scrutiny, and the scrutiny reporters see other checklist of the scrutiny and they proceeded further. If there is any defect notified, the defect notice will be issued, time for the refiling will be provided, or if there is no defect, then the case will be registered as per the standard process. Let me see login of the nodal and what activities a nodal can perform. So this is the disclaimer, and here you will see in the left menu User creation, where the nodal can create sub-office users, edit sub-offices. Here they can manage the cases, assign cases sub-office slash BO, assign cases list, the case which are already been assigned, assign file verification of the cases, the three things which I previously told, assigned and verified cases, and BO not found cases list, and the cases where BO is not found. So most important menu is assign cases sub office slash BO. This is the primary activity which need to be performed by the nodal for the representation of the cases. Here all the cases will be available, and in column status of verification you will see verification, neither it's assigned nor verified, because at the time of the list received by the nodal, the verification was not assigned, so it's not verified. In some cases it could be assigned but not verified, as per the status will be available. To assign a case to a BO, you can just click on the proceed, and here there are two options, the sub office and the BO office. In BO office you will say by default it's a center nodal, so center is by default is selected. It can select sub jurisdiction like Delhi North. It can select next jurisdiction, the Daryaganj. Then the role for this we can say registration site visit, and here we will say the range 1, and as per the above selected fields, available users in that particular range will be populated in this drop down, all the BO users, and you will select the appropriate BO personnel, and as you will select it, you will see the mobile number and the email is auto populated, and when you will click the submit, this email ID and this mobile number of that BO official will be used for the communication of the representation for the case. For the next time, all the communication regarding the case will be sent on these two. There's one more feature where a nodal can transfer a case from one to another. Maybe it's assigned to the one BO and it want to be assigned to some other BO, that can also be done. Assigned cases list. Initially, there was an issue that until the case is verified, the case cannot be assigned for the BO. The 7 days timeline, when the verification timeline ended and the case landed to the registry team for the further scrutiny and the listing, and no nodal was able to assign a representation for that particular case, because initially the stay was determined by the verification by the tax official in case of taxpayer filing. So now that's both two different things, the verification of the case and the representation of the case, both are independent now. Even if the case is not verified by the tax official, it can be assigned for the representation, so that won't be any other issues. And one last thing I want to mention, because in last few days we have seen approximately 20,000 cases have been filed, and 12,000 are from the taxpayers and 8,000 from the tax officials. As per the stats we see, approximately 40-60 ratios there. Even the taxpayer, they need to submit court fee, they need to submit pre-deposit, and there are various other manual activities are there. They have filed more, so we are also expecting you all will also support and file quickly and more. That's what we want. So if there are any other questions or any issues you are facing, our support desk is active for everyone. You can raise the tickets. I will show you the link available in the photo, in CIS portal. Not Sophia, sorry. Here. And in the header also, help center. User manuals are there, and there are different advisories which have also been mailed to all nodals. What are the activities nodals and BO need to perform and how they need to be performed on the portal. So I hope most of the people have received the advisories. And recurringly, in each 1 or 2 month, any updates we are also mailing to all mail IDs we have available on the portal. So we'll start the question answer session. If there is any questions regarding spreadsheets. As Kapur sir also told, the e-filing template download, this is a kind of Excel sheet which is exact replica of the e-filing system. The tabs we seen over there, all the tabs are there. All the tabs we have seen over there, they have been mirrored over here. So before even logging into the portal, you can just collect all the information and fill it over here and get it ready. And after, when you will log in into the portal, and you will just directly copy paste them or select the drop down, you will not need to just keep the portal on the session, keep logged in for 1 hour or half an hour. So that will be much easier to prepare the data in offline mode and provide it someone if somebody else is filing, and you, that will be much easier to rule for this because it works online, doesn't need internet, doesn't need the portal. This sheet can be filled and can be provided to the person who is going to file on the portal, and it will be a very handy tool if you use it. And every field and data is just a replica of the portal itself. Very soon in near future, we are also providing a functionality where you will just fill it online, offline mode, and that file will individually be uploaded to the portal. You won't need to just copy paste the data or the select the drop downs again and again. So in the next 2.0 system, there are a lot of other features, the AI enabled features, and this directly offline upload system. These all will be available, and these are very soon they are coming up. So thank you everyone. Thanks for coming here. Yes, nodal officers directory we have in backend as a masters. So because it's a manual record which provided by the GSTN. So we keep in the background in the database. Yes, if some officer gets changed or the gets retired or the transferred, then that information is manually being provided from the GST to us. And we are still working on this situation because most of the time we are not promptly updated about it. That if some officer is getting changed from some other jurisdiction, some other state or the center, so we are trying to find out a quicker way to get identified if some changes in the nodal officer scenarios happens, or in the BO official also. Right, sir. Right, sir. So for now, it's manual. We get manual orders because many times the orders are manual in the paper. So say this being sent to the GST and they send to us, then we update that on the system. So we are finding a automated way for the search. So time is low. So thank you everyone. After some time, we'll start the Q&A session, and you can ask any questions if you have.
Thank you, sir, for that highly informative and insightful live demonstration. I would request the stage committee to arrange the dais for our esteemed guests for the upcoming question and answer session. While the dais is being set up, let us revisit upon the need for the tribunal as we have learned till now. So as far as we have learned, the GSTAT is a cornerstone institution in India's GST dispute resolution framework. The need for GSTAT stems from the complexities inherent in a nationwide indirect tax regime that spans multiple jurisdictions, transactions, and multiple sectors, with GST being one of the most significant tax reform in India. Disputes relating to classification, valuation, input tax credit, place of supply, and procedural matters are inevitable. A dedicated appellate tribunal equipped with both judicial and technical expertise is therefore essential to ensure consistency in legal interpretation and to provide timely relief to the aggrieved parties. As we are about to start the question and answer session, I would request our esteemed dignitaries to again take their seats on the dais. Sir, ma'am, please come on the stage, please. After the insightful presentations, we shall now move on to the question and answer session. This session provides an excellent opportunity for the officers to seek clarifications, share their experiences, and discuss any challenges that they may be facing in relation to the filing, processing, and management of appeals on the GSTAT portal. Participants are requested to briefly introduce themselves before raising their concerns and keep their queries concise so that a larger number of participants may be benefited. I would now request Sri Jyotiraditya, Additional Commissioner, CGST Delhi East Commissionerate, to kindly take over from here as he will be moderating this session. With the permission of the Chair, the floor is now open for questions.
Thank you, Yogita. Uh, can we have the people who are intending to ask question? Can you raise your hands so that we can go one by one to you? Can you, Commissioner Delhi South, can you bring the mic to him, please?
Good afternoon, everyone. I am Dinesh Kumar, Commissioner CGST Delhi South. I have one question regarding refund application or refund appeal. In some cases, so-called notice is not being issued, but all details are there in the refund order. When department is willing to file appeal before the tribunal, then they find some difficulty because they don't have the so-called notice, and without uploading so-called notice, appeal cannot be filed. So portal can provide any alternate solution that we can use not applicable, or can we upload the refund order in place of so-called notice?
Yes, sir.
So speaking about that relaxation in scrutiny, which refers to show cause notice. Actually, this notification or the order is an internal arrangement which has been made public. When we saw that we are not getting enough cases for hearing also, we decided that at the principal bench that we'll ask the registry of each of the bench to see only if these five documents are available. Supposing in one case there is no show cause notice, then show cause filing of show cause notice is not mandatory. The only thing is that you have to mention it in your facts of the cases.
Thank you, sir. Yeah, please go on.
Sir, actually the issue is
Without the SCN document, the process is not getting completed. This is the issue where SCN
Okay.
is not there.
Noted. Actually, there is a misreading of the notification issued by me. This was also put to me in one other seminars, where they say that if these five documents are not filed separately, then also the importer or the registry is issuing defect notices. It's not so. It is not so. Actually, the defects that has been listed are something about 28 categories which defect can be listed. This is the you can say the first notification that I had issued is substance over form. If substantially the appeal is constituted or perfected, then it should be admitted and it should be heard. And it was still not understood by many registry of the state benches. So I had to give another notification that these are the five documents which you require actually in a case where the appeal is filed by the SSC. But in a case where the appeal is filed by the revenue, there is a separate paragraph for that. And if it is not, is it Mr. Chandel that if so-called notice is not given?
Can I assist?
Eh?
Can I assist, sir?
Yes, please.
Sir, what he's asking is, hi, Mike, built in. What he's asking is for the refund rejection, they have not specifically issued the show cause notice, right? When you went to file an appeal, they were asking for show cause notice. So I want to ask you, how could you reject the refund without issuing RFD 08? RFD 08 is the show cause notice for rejecting the refund. RFD 09 is reply. Afterwards, you would have passed RFD 05 and 6, which is either for sanction
Let
or
me
rejection.
intervene. Brother, we are here to answer the question, not ask questions. Please. बुरा मान जाएंगे.
But normally you are, can I just, I think you are saying is that RFD 01 was filed and it was rejected. That is how you issue. No, no, see, see, in the normal course, please understand, in the normal course, these are the requirement. SCN, OIO, OIA, like sir has mentioned, that these are the requirement. This is the registry going through. If these are there, rest we are very liberal. We are not raising any defect memo. So if you are mentioning this in your appeal, that there was no show cause notice, registry will accept it. But I think your point is that RFD 01 was there, based on that only rejection took place. So there was no separate show cause notice issued. Are you saying that?
Arun, you would like to elaborate on that, Arun? Yes, that goes in. Even then, the so-called notice is being sought.
Directly issued the order.
I understood the question. There is a case, I'm not going to 04, 07, 08, no numbers.
Yes.
A case where there is no show cause notice and you are unable to file it. That is not the intent of the GSTAT. If it is so, it will be resolved during course of the day.
Yes.
Sir, what is
May I have the next question? Yeah. Commissioner
Sir,
Delhi North.
Shailesh Kumar, GST, Commissioner GST North. My question is related to procedural part, which we had discussed during the meetings also. Sir, in some cases it is found that even after authentication and system is showing that it has been filed, but neither PDF of a PL7 is available, not it is being downloaded. So in those cases, the person who is filing is in double mind whether it has been filed or not filed. So what is the solution of that kind of?
02?
Thank you, sir. You're not audible. Can you just speak?
If you've received the APL 02 2A Part A, the provisional acknowledgement number, then your appeal is filed. Consider it filed. Until you receive a provisional acknowledgement number, it's not filed.
But the point is, sir, that we are not able to download the APL 07 at later stages also. If APL 07 is not generated at the time of filing appeal, we cannot download it in later stages also.
Actually, the process is when you reach to the last step, You will download the APL 07, then you will re-upload and sign it. That only the way to finally submit it for
Yes.
generating APL 02A part A, the provision acknowledgement system.
Yeah.
So if you have not downloaded it, then how you can upload it and how you can sign it? You must have downloaded it previously.
Yes.
If the case is filed and after that you want to see all these documents, not just APL 07, along with all other documents which you have uploaded along with the appeal, that is also available in the DMS. You filed cases in My Appeal Civil section. You will go, you will click on the filing number. That filing number will let you open a DMS system. That DMS system contains all the details, including Appeal 07, all the documents you have previously uploaded. Everything is available over there.
Thank you, sir.
We'll quickly take 2-3 more questions. Any other question? Yes, Arvind, you wanted to ask? Yeah. Arvind, please. Acha. Yeah, Commissioner East. Yeah, please, please.
फाइल हो गया समझ रहा हूँ बी आनी चाहिए अपनी नंबर अलर्ट रहते तो वो बोलने वो
Mike, can you check the mic, please?
Good morning. I am Commissioner CGST Delhi East, Sangeeta Karmakar. Sir, my question is, as per GSTAT procedure rules, in case there is an OIA which covers multiple OIOs, order in originals, in that we have to file separate appeal forms for the corresponding OIOs. But what is currently the limitation right now in the portal is that against one OIA, that is order in appeal, we can file only, it permits filing only one appeal. That is basically for one single ARN, you can, which corresponds to one OIA, you can file only one appeal. So in that case, for multiple OIOs, how do we file appeals for the other cases?
Ma'am, if you permit, I will just like to elaborate on this. So whenever an OIO, whenever there is an OIA containing multiple OIOs, the appeals commissionerate are doing two things. One, in one of the situation, one of the practice they are following is that they are issuing only one ARN for one OIO on the portal. Whereas in some of the appeal commissionerates, they are doing it, they are filing, for example, there are 5 parties for which that appeal is applicable, they will issue 5 ARNs on the BO portal. So our dilemma is how to handle these two kind of parallel systems they are operating. So in case there is a multi-party OIA, in which the appeals commissionerate has filed a single ARN, how will the field formation respond to such a situation? Chandelji, if you can just, yeah, maybe somebody.
I will clarify what you have very rightly pointed out. Rule 18(3) subclause A, I suppose. It mentions that in the case one order in appeal has multiple OIOs, then for each OIO, separate appeal has to be filed. Correct? And then there can be also a situation in an order in original as well as an order appeal. There are multiple persons in the same order. There were like directors, the CFO, penalties have been imposed. Now, the rule is very clear. Normally, what happens is when we pass the OIA, earlier also before this, we used to give number, for example, 32 to 36, 38, like number of OIO, separate numbers are given, dispatch when we should order. I had discussed with the NIC also. In many cases, multiple numbers have been given. They are being taken care of. Some issue is regarding where only one number is there. So there, I think, Vivek, if you can elaborate on that.
Sure, sir. So the situation is there are two type of situation in this scenario. What we are discussing is one is where all the multiple parties are the GSTN entities, the taxpayer entities, or there could be few GSTN, or one is the company and few other the directors, the individual people who doesn't have the GSTN number. In this scenario where one company and multiple directors have been ordered appeal, there is 4 people. Recently there was a scenario, company and 3 directors both were combined in one order and appeal. So that in that scenario that was not the issue because the entities were different. Company can file on its GSTN number and individual people can file on their temp IDs. But in the scenario where only the multiple GSTNs are combined in one order in appeal, we have blocked this single ARN CRN per appeal because of to just stop the redundancy of the filing per ARN because it's a digital system. If we blanketly allow just to file multiple appeals on one single ARN, then mistakenly one ARN could be used for the multiple filings, and maybe sometime user doesn't know about it. Sometime from one account to another account, to just to make sure that one appeal, one APL 04 order will result into one APL 05 appeal, or one RNCRN to one appeal. That's why that was bounded. For the solution of this scenario where multiple GST parties are bounded in one order, they can, first party can file directly, and other parties can use #1 in the RNCRN by using the method of without RNCRN. File without RNCRN is the second method of filing. You use the method file without RNCRN and use the same impugned order number, adding #1 at the end of it. The same order will be challenged, and #1 means the next party is filing the appeal.
Let me just share my thought to it. There are two types of composite orders, like five cases, hard analogous. In all five cases, the respondent and appellant are same. The second time is that either the appellant or the respondent is same, but the other party is not same. Most of the cases, the appellant is the same and the respondent are different. In the first type of case, where one composite order or analogous order, whichever name you call, one ARN CRN is generated, then you can file one appeal and that will take care of. But in cases of supposing 5 different respondents, same question has arisen about 5 different entities, different entities. But one one ARN is given, then that #1 principle can be taken and 5 appeals can be filed. But these are all, we should not close our eyes and ear or minds to these things. These are evolving situation. These things will present themselves. We have to be very proactive and a open-minded way. We have to meet it. नहीं हो पा रहा बल्कि अबैंडन करना नहीं है कि इमीडिएटली जाके नहीं फिजिकल फाइल करो या बंद करो जीएसटी या जीएसटी रेजिम ही बंद करो. सम पीपल आर सेइंग जीएसटी रेजिम बंद कर दो. आई हार्ड समबडी लॉन्ग बैक. अब तो कोई मेरे सामने नहीं कहता, सास नहीं करता है. The senior officers ask. Let us see
the junior officer, sir, ADCs.
You don't call a junior officer, you call them DCs, SCs.
Sir, ADC is asking. Arvind, yeah, please.
So this is Arvind Kumar Chaurasia, Additional Commissioner, CGST, Delhi South Commissioner. So my question is regarding this filing of interlocutory applications, sir. And sir, while going through the presentation of Kapoor, sir, so there was mentioned that this Form 01 or this interlocutory application can be filed for this extension of time or for this condonation of delay or for the stay or for this early of hearing. So can the same be filed for the bunching of these appeals which have been filed on the identical issue? Because department has filed several appeals on the identical issue. So for example, whether the adjudicating authority should impose a single penalty or this multiple penalty for the multiple contravention under these various clauses of this subsection 1 of section 122. Because if that
we got your question. Sir. Whether it can be used for bunching of cases.
Yes.
In fact, it can be used for bunching of cases. Either identical question of law, yes, or same cause of action, mixed question of law and fact, right, in different benches or the same benches. That can be used. That is, in fact, we have been telling everybody that that can be used also for transfer of cases to the principal bench and on the principles of identical question of law. It can be, yes. Next.
Okay. Dinbandhu, yeah.
Good afternoon, sirs. I have a question. I am Dinbandhu Diwakar, Additional Commissioner, Delhi West. Since so many technical things are going on, since our filing deadlines are so critical, can we set up a dedicated tech support channel for our department? This would be super helpful for fixing urgent show-stopping errors like digital signing failures, upload errors, or form generation glitches, making sure our final submissions aren't delayed and we meet our strict compliance deadlines, sir.
You see, before us, we have two types of litigants, appellants, really, taxpayers and the revenue. And as far as the GST 80 is concerned, both the appellants, both the parties are equal. We cannot give an additional desk to you, but we have a desk, a help desk, in each of the benches, and in fact, in the principal bench, GST 80, there's always a team of experts sitting who can take call and resolve any ticket that we issue. As far as your specific question is concerned, I think the right person to answer it is Madam Rimzim. She can.
No, no, I think we need to develop that alert system internally for because you're asking whether there should be an alert when there is a delay in say filing appeals or in filing the cross objections. Is it? This is what you're trying to ask?
Ma'am, I think he was asking he was asking because like this kind of session workshop took place, so which resolved many queries, but I'm sure there are several other queries which, because of the paucity of time, they will not be able to address here. So what he is trying to ask is can the GSTAT provide a dedicated kind of hand holding for the next couple of days so that whatever pending appeals are to be filed, technical snags, technical issues that if they come, they can be handled. Yes.
I'll just add, in Delhi branch, we have a help center which is working every day, 3 to 5 officers. Initially also were coming, we were doing hand holding. In fact, even our assistant registrar has gone to the commissionerate in West. I think 2 commissioners they had gone, and to know why the people are not coming, why the notice is not being received. So there are officers who are coming to us and taking the help. For example, that there was an issue regarding, like I said, digital signature issue was there. Then uploading, digital uploading, there was some issue. Though all those issues have been resolved. So help center is working every day, 3 to 5. Any officer has any issue in filing can come. Otherwise, like President sir has already mentioned, in the principal bench also there is a dedicated team. NIC staff is there, officers are there. They will help you.
Thank you, sir. Any other question you wanted to ask? Yeah, please. Mike. Okay.
Good afternoon, everyone. My name is Prerna Singh, AC Vasant Kunj, Delhi South. So recently, I was making my login ID and credentials at GST portal, GST 80 portal, and I realized that it is very individual centric. So my credentials are being made instead of a division or office based. So is there a proposal to make it division based or office based so that there is a continuity even after the individual get transferred?
Yes, sir. Because I would just like to add on that, because all the alerts which are going is going to that particular individual's email address and phone number. By chance, if the person is on leave for 4 or 5 days, the department is not aware. In fact, the commissionerate or not neither the commissionerate nor the zone, neither of any supervising authorities are available to. They are aware that there is something of this sort is going on. So.
You can have a seat. You see, the system is built like this. The GSTN portal and GST 80 portal are interlinked. Whatever information is there in the GSTN portal are auto-populated. So initially, supposing, have you read the 2 judgments authored by the principal bench on GST, on CGST? Sterling Wilson versus State of Odisha, or Dow Chemicals versus State of Maharashtra? Anybody who's read it? And I am looking at the cream of the GST 80 enforcing officers. Cream of the Indian whole of pan India. I'm really surprised. So let me share the experience. The first case was of Odisha. We'll not go into nitty-gritty of it. But the appellant was a company called Sterling and Wilson. When they filed the case, the portal showed as some Madam Daruwala is the appellant. How? Because her registration number was used to file the case. Instead of the portal showing it Sterling and Wilson, it showed as individual director of the company. Similar thing happened in Dow Chemicals also. So we are into it. We are in the process of making the independent of the individual centric, and it has to be made office or post centric. But it will take time. We are aware. Slowly it is being done. And thank you again for asking the question. But मुझे थोड़ा सा I feel like I expected a better response from you, but this update judgment पढ़ना चाहिए था.
I'm sure they will do that.
Sir, if I can just supplement what he has mentioned. If suppose officer is not available immediately, whatever goes to BO, copy also goes to NO. NO is at higher level. NO also gets. So in case BO is absent on leave, the concerned NO is also alerted.
Sir, just a second, sir. Our NO is here. Arun, are we getting it? Copies.
I'm the nodal officer in Delhi, sir, and I'm not getting any emails about next hearing. And
No, nothing is getting, sir. No, we are not getting anything of that sort.
So this nodal office is not getting anything. Even cause list for the next date, the hearings are coming, or this case is being
Any
stayed for the
date,
next date.
any
This
alert is not
only
reaching us.
which are coming on email IDs are
Nothing is reaching us. Okay, Arun, what we'll do is that we'll get one-on-one with
I'll
them.
provide the
Yes,
nodal ID.
sure. Yeah.
Question relates to the visibility of the taxpayer's appeal. Sometimes the taxpayer is appearing and is approaching us that he is filed an appeal, but we cannot view it on the portal in certain cases. So, can you please explain the mechanism to verify or to view the taxpayer's appeal on the portal?
Any appeal filed by any taxpayer first goes to the nodal login. Then nodal defines which BO to assign this case for the representation and for the verification of the case. So when the nodal will assign a specific BO for the representation and the verification of the case, then the BO will be available to see that case. Until that case is assigned to you, it won't be available.
Thank you.
Can I
I
supplement
think
the
we are.
Something.
7 days are very.
You want to like
Verification.
Can't we have a standard operating procedure be issued for departmental appeals covering filing responsibility, party description, document requirements, defect rectification, digital signing assignments, and hearing alerts?
So SOP is there already. SOP actually, you see, ma'am, please be seated, please. The litigation policy of different states and centers are different sometimes. So SOP has to be issued by your principal chief commissioner only, as far as your commissionerate is concerned. That will not be the duty of the GST 80. GST 80 is actually constituted to dispute resolution or adjudication of dispute. We are taking up a additional step of making everybody aware of how to file it, how to come before us,
Sir.
and how to argue before us.
That's right, sir. We will just, because of the paucity of time, we'll just take one more question, sir, and so that we can break off. A last question, please.
Madam.
Yeah, Sanjay, please. Yeah.
Good af-
Okay.
good afternoon, sir. I'm Poonam Dhawan, Superintendent, sir. I want to ask, may the GSTAT portal publish a list of known technical issues, interim workabouts, and resolved bugs for the benefit of department as well as
I could not follow. हिंदी में बोली कोई बात.
So may the GSTAT portal publish a list of some known technical issues so that the same helps to avoid the confusion and reduces support requests.
Sir, I think what she is asking is that if known issues are mentioned, I think sir has already during the presentation mentioned such technical.
We'll consider. We'll take the help of Brother Kapoor to make such a list. And thank you. Thank you.
Sir. Sir, I think last question Sanjay is asking. Yeah. Take the mic, Sanjay.
There are two questions. When we receive any appeal from a nodal officer and from the zone in the commissionerate, and we transfer to the divisions, but it is not appearing in the division. What my colleague was saying in the from Vasanganj division, actually, when we transfer the appeals to the divisions, it is not appearing in the division. So you can say back office. Second question: when we transfer these cases to divisions, we are all the zonal appeals are appearing there. There is no filter mechanism कि हम अपने दिल्ली ईस्ट के ही cases को उसमें filter कर सकें. After assigning.
The standard practice we have at our nodal and DO mechanism is all cases landed to the nodal after filing. There are two steps to assign those cases. First is to assign for the verification of the deposit and verification and the APL04 details. And when that is the window of 7 days, it should be completed or the case will be to the scrutiny after 7 days. Thing was, if a case has not been verified, then it cannot be assigned for the representation. If 7 days has been passed, because 7 days is quite a short window, and in a few months we have seen a single case has been verified by any team across India. Even not even assigned for the verification by the nodal. So after 7 days, the case gets locked. Now after 7 days, because the scrutiny is working on it, you cannot verify the details because 7 days have passed. So the case is not verified. So there was a lock on the case by which the case was not able to be assigned for the representation. And it will not be possible to the nodal. Maybe in the last 20 or 15 days, that lock has been removed after a long discussion on this with GST and also with the GSTAT, that we should remove this lock and make these two things which are also mentioned during the conversation. But now these two, the verification of the case and the representation of the case, both are individual independent activities. It doesn't depends for the representation if the case is verified by DO or not. It can be assigned for the representation. So if anybody of you have been done this in last 1 or 2 weeks, I don't think that will won't be any issue with that. Last 15 to 20 days, because nobody was assigned for the verification. That's why cases was locked. Now it's not the issue. Maybe last 20 days.
Initial 7 days are very critical for the BO and NO. You are supposed to pre-deposit, assign the case. If you miss that chance, there's something like our APR force forwarded to the registry. Registry will scrutinize. After scrutiny time, you will not able to again get it any access. Now they have unlocked that. So now I think from now onwards you'll be able to use.
सेकंड क्वेश्चन सर, आफ्टर असाइनिंग वो हमारा पूरा जोन का दिखाई दे रहा है.
The reason because case was not initially verified, that's why it's not showing. Now any case which is being transferred for the representation, assigned for the representation, will be available to you in the normal general scenario as it should be.
Yes. Somebody from this side wanted to ask any question? Yeah, you were. Yeah, please.
Afternoon.
Please hold mic to close. Yeah.
To nodal officers role in commissionerate. Actually, sir, by mistake, if we send case to wrong division, then there is no option to reassign or pull back the case. And sir, other suggestion is that in the list of cases assigned, if there is a column that which particular division the case has been assigned, the monitoring will be more effective. Verification may be done in less than 7 days. Thank you.
Okay, the situation is if the case has been assigned to a wrong BO, then there are two scenarios. One is only the case is assigned and the person who has been assigned for the representation, he has not done anything. Means if there is taxpayers APL 05 has been filed, it reaches to the nodal. Nodal accidentally assigns it to a wrong BO. And if that BO also filed a cross objection on that, then the case is locked because the file is under processing, because he has filed the cross objection on that appeal 05. If that person has didn't do anything with the case, then this case can be transferred to any other BO. Case transfer functionality which I was showing in the menu is specifically made for that scenario, but the case must not have been provided any activity but that BO person which has mistakenly assigned for.
Sir, there are few cases appearing on the nodal officer login where I cannot reassign the cases. Once they are assigned through sub office to bank office,
Right.
then I cannot reassign them. But if I am directly assigning the case to BO, then I can reassign them. There are two scenarios. When I'm assigning cases directly to BO, I can reassign them. But I'm assigning cases to BO through sub office, then I cannot reassign them.
The case assignment or the transfer of the case assignment is functional in a way that regardless it's directly on the BO or through the sub office, it doesn't depends on it's through a sub office or the directly to the BO. It's not been designed that way. If there is any such issue coming with that particular case, there must be user have started some activity on that particular case. We can see specifically the most of the cases it's not the issue across the India people are using the portal, but I'm not saying that portal 100% there could be no issues. There could be once in a blue moon, there could be some issues or the glitches over there, and we are ready to act on it, and the totally dedicated support desk is available there. So if there is any issue anybody is facing, we are here and we are ready to listen and to resolve it.
I'll request ma'am, the Principal Chief Commissioner, to depute Mr. Arun to GSTAT. You come, we'll give you tea and coffee, no problem. Whichever is your preference. And sit with Chandil and resolve all the problems. And नहीं, इतने में काम नहीं होगा. You have to communicate all these resolutions, जो solutions होगा, to all the officers at least of the Delhi NCR. जो हमारा 4 bench है, दिल्ली, गुड़गांव, गाजियाबाद and principal bench. इनके पहले आप, that is the first duty. Of course, the duty is to the nation also. You can do जितना the more the merrier. Thank you, sir.
Thank you, sir. Sir, we have already running 40 minutes past the schedule. So, as you have already provided a Spock in the form of Arun Tyagi, so I will request you, all of you, whatever doubts you have, send it to Arun Tyagi, and Arun Tyagi will, he is the nodal officer for Delhi zone, the Principal Chief Commissioner Office. Thanks a lot for making this session a very highly interactive session. I will request Yogita to come and take over. Thank you.
थैंक यू सर। देवियों एवं सज्जनों, निसंदेह ही यह सत्र अत्यंत ज्ञानवर्धक, प्रेरणादायी एवं उपयोगी रहा। अब मैं आयुक्त दिल्ली पश्चिम मुख्यालय श्री दिपिन सिंगला को मंच पर आमंत्रित करती हूँ कि वे श्री विवेक चंडेल को एक पौधा रूपी आभार के व्यक्त में एक पौधा प्रदान करें। श्री विवेक चंडेल, सीनियर एडवाइजर एनआईसी, कृपया तालियों के साथ उनका स्वागत करें। अब मैं श्री मनोज तुली, सीनियर एडवोकेट एंड कंसल्टेंट को मंच पर आमंत्रित करती हूँ और मैं सीनियर एडवाइजर एंड कंसल्टेंट जीएसटीएन को और मैं श्री दिपिन सिंगला से रिक्वेस्ट करती हूँ कि वे उन्हें एक पौधा भेंट कर उनका आभार व्यक्त करें।
Let me share this thing. Vivek is the face which is visible to everybody. The man who is working behind him is Mr. Tulli. He is the head of the technical team.
अब मुझे अत्यंत हर्ष एवं गौरव का अनुभव हो रहा है कि मैं माननीय अध्यक्ष जी स्टैट न्यायमूर्ति डॉक्टर संजय कुमार मिश्रा को आमंत्रित करूं कि वे अपने समापन उद्बोधन एवं भविष्य की दिशा पर अपने प्रेरणादायी विचारों से हम सभी का मार्गदर्शन करें।
Thank you. So, good afternoon. It has been really vibrant half a day. Many questions were asked and many remain unanswered also. Let me speak one small experience of mine. When I became a judge of Odisha High Court, I voluntarily asked to be included in the academic committee of the High Court. As a committee of judges which looks after the Judicial Academy, Odisha Judicial Academy, and the training for the judges and magistrates. And I have been involved in many seminars, and the seminars that has have delegates from the judiciary, especially district judiciary, are very, very disciplined. They don't generally ask very searching questions. I find that all of you are really concerned and you have made some really pointed and searching questions, and that is a good sign, because that is a sign that you want to learn the process and participate in the process of resolution of a dispute regarding GST, imposition of GST, etc., and the ancillary questions. Now, if I may say that all your questions will be answered in a seminar of a half a day, then it will be a utopian concept. It cannot exist. Even if you go on for 3 days, you'll still have questions. My belief, right from the beginning in 2009, when I became a member of the Judicial Academic Committee of the Odisha High Court, that any seminar, if it can be called successful, then carries more questions in the mind of the delegates than answers. And I hope you carry more questions in your mind than you carry the answers. And the answers to the question that you carry either lies in your mind or in the internet on the system, or if nothing is there, Mr. Arun is there always to be a gap between the knowledge persons who have the knowledge and the seeker of the knowledge. I would like to thank the Delhi Commissionerate for arranging this half-day seminar, a very short notice within 13, 14 days. And from the attendance, I can say that everybody is very enthusiastic of it. A special thanks to, of course, to the principal chief commissioner, whose idea of having this seminar has also resulted in about 30 to 40 seminars throughout the country in different levels. Even few days back, Delhi bench was having a hand-holding working session. Then Ghaziabad is having, Gurgaon is having. That is which is we can hard. Uh, throughout the country, we can see that there are so many questions to be answered, so many uh, riddles to be solved, so many obstacles to be uh, overcome. अभी बहुत सारे इम्तिहान बाकी है, बहुत सारे मुकान बाकी है, अभी तो नापी है मुट्ठी भर जमीन, आगे पूरा आसमान बाकी है. There is another aspect I will just uh, tell briefly and then we'll conclude. There's if you go to the APL 07, there is a field or a box which asks you to give what is the grounds of statement of fact in 2000 characters. It is being made to 5000 characters, and then grounds of appeal in 2000 or 5000 characters. Now many people are asking, we are giving a detailed grounds of statement of grounds or statement of facts and also grounds of appeal led in the appeal memo. What is the need of again giving it in the APL 07? Did you get my question? Why I'm saying that? Now, first, when it was conceived, we conceived that APL 05 form, whenever or 07 form, whenever somebody looks at, he gets an idea about the case, what the entire case. Then somebody said that, how can I write the grounds of appeal in 2000 characters? So we are making it to 5000, but 5000 is also, supposing my grounds of appeal runs to 15 pages, how can I do it? Still you can squeeze it. If you have an understanding of law and the facts of your case, you can express what are the reasons for which you challenge the order impugned in just 3 to 5 sentences. Because I have seen that. I have been in litigation for 40 years now. I have seen people doing even in lesser number of characters. So that is one thing, that show the reader in one page what is the appeal is about. Second, the professionalism and preciseness of a appellant comes out when he puts in the grounds of appeal and statement of fact in a very short field. The third is, which is actually late, which transpired to us in a later stage, there's a question of bunching up cases. Bunching up cases only on the question of mixed question of law and fact. Supposing mixed question of law and fact is arising in Maharashtra as well as in Delhi and also in Kanpur and also in Calcutta. So there is the chance of 4 different state benches giving 4 different kind of judgment. So that is a always as advisable to bunch all the cases and assign it to a particular bench that will be binding on all. Now, how to find this? So somebody said that AI, an AI can help. Now, there is a tussle between my technical team one hand and a, a gentleman, two gentlemen rather, coming and who wants to help the GSTAT pro bono. They say that, sir, we'll provide you an AI which will tell you how many cases are throughout the country on certain questions just by looking at it. You can take a decision. But the technical team on the other hand will say, what about my data safety? I cannot allow anybody and everybody to enter into my data, the cloud, and take out information from that. This can be resolved. Can it be resolved? Supposing we have 05 complete, the fields of statement of facts and statement of questions of law or question of grounds of facts are there. Only on that information, if that is downloaded, collated, taken, made a one document, one digital document, and in AI is given, then the entire country's picture of what are the question, what cases can be bunched, can be found out. But again, this is a wishful thinking of the president. Can we or can we not? Can we or can we not? Is the question. In any case, it was nice talking to all of you. No system is perfect from the beginning. It generates itself. And that's why in sociology, there's a concept of sui generis. The system generates itself. System, I am not meaning the portal itself. The system means the taxpayers, the tax professionals, the revenue officers, the adjudicating authorities, then the first appellate authorities, then the second appellate authorities, the law of the land, and the technology available to them. On top of it, the technical team and the portal. This constitutes the system. The system will generate itself, and we think and we believe that we can and we will. Thank you very much. Jai Jagannath. Bande Mataram.
धन्यवाद माननीय महोदय, आपके प्रेरणादायी संबोधन के लिए हम सब आपके हृदय से आभारी हैं। आज की इस ज्ञानवर्धक एवं अत्यंत सफल कार्यशाला के समापन की ओर अग्रसर होते हुए यह उपयुक्त अवसर है कि हम उन सभी को हार्दिक कृतज्ञता व्यक्त करें जिनके मार्गदर्शन, सहयोग एवं सतत प्रयासों ने इस आयोजन को सफल एवं सार्थक बनाया है। अब इस अवसर पर मैं आयुक्त CGST दिल्ली पश्चिम श्री दिपिंग सिंगला को धन्यवाद ज्ञापन प्रस्तुत करने के लिए सादर आमंत्रित करती हूँ।
आदरणीय GSTAT अध्यक्ष एवं सदस्यगण, प्रधान मुख्य आयुक्त दिल्ली जोन, वरिष्ठ अधिकारीगण, देवियों और सज्जनों, केंद्रीय वस्तु एवं सेवा कर दिल्ली जोन की ओर से मैं GSTAT के अध्यक्ष डॉक्टर न्यायमूर्ति संजय कुमार मिश्रा जी और GSTAT के सदस्यों का आभार व्यक्त करता हूं कि उन्होंने इस कार्यशाला में भाग लिया और अपने बहुमूल्य विचार साझे किए। उनके मार्गदर्शन, व्यवहारिक सुझावों एवं अधिकारियों के साथ खुलकर हुई बातचीत ने GSTAT की प्रक्रिया के बारे में हमारी समझ को काफ़ी बेहतर बनाया है और क्षेत्रीय कार्यालयों की कई महत्वपूर्ण चिंताओं का भी समाधान किया है। मैं प्रधान मुख्य आयुक्त दिल्ली जोन के प्रति भी अपना आभार व्यक्त करता हूं, जिनकी दूरदर्शिता और पहल से इस कार्यशाला का आयोजन संभव हो सका। क्षमता निर्माण की इस महत्वपूर्ण प्रक्रिया के लिए अधिकारियों और हितधारकों को एक साथ लाने में उनका निरंतर प्रोत्साहन और मार्गदर्शन बहुत महत्वपूर्ण रहा है। मैं प्रधान मुख्य आयुक्त दिल्ली कस्टम प्रिवेंटिव और प्रधान मुख्य आयुक्त मेरठ जोन एवं सभी जोन से आए अधिकारियों का भी आभार व्यक्त करता हूं, जिन्होंने अपना कीमती समय निकालकर कार्यशाला में भाग लिया। मैं NIC से आए अधिकारियों का भी आभार व्यक्त करता हूं, जिन्होंने अपील दाखिल करने की प्रक्रिया में आने वाली समस्याओं का समाधान साझा किया। आज हुई चर्चा ने ट्रिब्यूनल और क्षेत्रीय कार्यालयों के बीच निरंतर संवाद के महत्व को फिर से स्थापित किया है। हमें विश्वास है कि इस कार्यशाला से मिली सीख और सुझाव अपील प्रक्रिया को अधिक कुशल, पारदर्शी और प्रभावी बनाने में बहुत मददगार साबित होंगे। अंत में मैं दिल्ली पश्चिम आयुक्तालय और CSOI के अधिकारियों और कर्मचारियों, आयुक्त श्री शौकत अली नूरवी तथा उन सभी लोगों के प्रति भी आभार व्यक्त करता हूं, जिन्होंने इस कार्यक्रम के सुचारू संचालन के लिए कड़ी मेहनत की। धन्यवाद।
धन्यवाद महोदय, आपके सौहार्दपूर्ण एवं सराहनापूर्ण शब्दों के लिए। अब हम कार्यक्रम के अंतिम चरण की ओर बढ़ते हैं। मैं सभागार में उपस्थित सभी से विनम्र अनुरोध करती हूं कि वे कृपया अपने स्थान पर खड़े हो जाएं एवं राष्ट्रगान और राष्ट्रगीत के गायन के दौरान गरिमा एवं अनुशासन बनाए रखें। आइए हम सभी अपनी मातृभूमि के प्रति सम्मान एवं श्रद्धा व्यक्त करें।
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
इसके साथ ही जीस्टैट पर कार्यशाला का सफल समापन होता है। सीजीएसटी दिल्ली जोन एवं आयोजन समिति की ओर से मैं माननीय अध्यक्ष, माननीय सदस्यों, विशिष्ट अतिथियों, अधिकारियों, प्रतिभागियों तथा इस आयोजन की सफलता में प्रत्यक्ष एवं परोक्ष रूप से योगदान देने वाले सभी व्यक्तियों के प्रति हार्दिक आभार एवं कृतज्ञता व्यक्त करती हूँ। आपकी स्नेहपूर्ण उपस्थिति और उत्साहपूर्ण सहभागिता के लिए पुनः धन्यवाद। नमस्कार, जय हिंद। देवी और सज्जनों, सभी को सूचित किया जाता है कि इस कार्यशाला में उपस्थित सभी गणमान्य अतिथियों एवं प्रतिभागियों के लिए भोजन की व्यवस्था की गई है। माननीय सदस्यों, माननीय सदस्यों, जीएसटी अपीलीय अधिकरण प्रधान मुख्य आयुक्तों तथा आयुक्तों से विनम्र अनुरोध है कि वे भोजन हेतु भूतल स्थित हॉल RV1 में पधारें। अपर आयुक्तों, संयुक्त आयुक्तों, उप आयुक्तों तथा सहायक आयुक्तों से अनुरोध है कि वे हॉल PR1 में भोजन ग्रहण करने हेतु प्रस्थान करें। अन्य सभी अधिकारियों एवं कर्मचारियों के लिए भोजन की व्यवस्था हॉल PR2 में की गई है। कृपया सभी सम्मानित अतिथि एवं प्रतिभागी अपने अपने निर्धारित स्थान की ओर प्रस्थान करने का कष्ट करें। धन्यवाद।